Pass on all the memo, please. Right. That's fine. Please.
This is the public interest litigation, not self-immersion object.
Yes.
When permitted to find indulgence of out of termination. And indulgence for one mention out of 6 versus this is the item number 39.
Pass on.
No, no, this is list item 39. The part of my appraisal works yesterday. Okay, for 2 kill or
Oh, let us see, sir.
as you
Let us see.
Senior is also appearing and filing the counter-affidavit.
Let it be called, madam. Are you in hurry? No. Just wait. Anyhow. No difficulty, sir. Just remind us, we'll adjourn. So that you can go through the counter. Don't.
Adjournment till Tuesday.
No difficulties.
Item number 1.
My lords, I may be permitted to appear online, my lords.
Oh. Why you are not appearing?
My lords, I am appearing online, my lords.
You are in the court. You can appear in the.
No, my lords, I am not in court, my lords.
Not in court. Oh. Yes. This is the blacklisting.
Yes, my lords.
I have gone through it. I will pass the order.
My lords, only 3 submission, if I may be allowed to make only 3 submissions, my lord.
You have already submitted a judgment yesterday.
My lords, only 3 points, my lords. That's it. I won't say. I won't say 3 more words than that, my lords. Three submission, my lords. My
What
lords,
is the first submission?
for non-supply of material relied on in the show cause does not violate the principles of natural justice.
Second submission?
For that, I'm just, my lords, showing 2001 8 SCC 604. It is 2 page.
Give the judgment. Where is your counterpart here?
Yes, my lord. If I may request Sashwat Das to just hand over the judgment, my lords.
Yes. What is the second point, madam?
Second is without prejudice to the above contention, it is further submitted that petitioner already had the knowledge to the material relied upon in the show cause notice, my lords, because charge sheet was prior to the show cause issuance of show cause.
Anyhow, then any judgment
No, my lords. With this,
in this. And what is the third submission, madam?
third submission is procedure as contemplated in Appendix 34 of OPWT is strictly followed. And for that, my lords, I am relying upon 2022 4 SCC 393 judgment.
Correct. We'll take care of that.
Yes, my lords.
Yes, you have to respond those judgments in reply.
And I'm only question I have received is that the violation of principle of natural justice.
That is what, yes. No, I understand your contention is that when the order of injunction was passed and there was there was an order passed to continue to complete the work within 8 months. That is not.
That is item 39.
Oh,
Here, Madam, so far as the case is that they say that on the 24th March 2021, I entered into the office premises at about.
Oh, this is that case. CCTV footage and all, everything. Yes, that was.
Besides that, and one in Sister says that charge sheet was filed by the time the show cause was issued is not a fact. That's number 1. Number 2, my lord, I also took the ground that I am not a registered contractor under the OPWT Contractor Registration Act. So therefore, the blacklisting provision of the OPWT code doesn't apply. That's a jurisdictional issue, my lord. And I'm just drawing your lordship's attention to 2 provisions of the OPWT code. The lordship can you have that? That is with respect to jurisdiction, my lord. How they exercise when it is not applicable to. Admittedly, I have no contractor license. Let's kindly first start with the definition.
Volume 1.
Well,
Yes.
it applies to the PWD works that the father is.
Where, from which provision?
Yes.
Well,
From the
introduction and definition.
introduction.
Yes, the code is intended to define the scope and functions of the officer in charge of the public works working under the administrative controls of the work, irrigation, power and development, so and so. So it's works department. Now, your lordship, the public work has been defined under 22. 1.222 means 1.2.22.
Page 15.
15, yes, ma'am. Page 15. Means civil work, public health engineering work, irrigation, navigation, embankment, drainage work, and electricity work. And then the public department has been defined. Public works department has been defined. Now, I'm not a contractor. I have not registration certificate is issued to 280 of which the book is same, my lord. That's the rule. These rules shall be known as PWD contractor registration rule and shall appendix 8, your lordship, and we have that.
No, I understood. Then 2 is no person shall be awarded any work except with the permission limit of the job, unless he has been registered as a contractor in accordance with this rule.
One. So I am a small scale industries. I am doing mechanical work for which this code doesn't apply. And I have no registration.
And where is the provision for the blacklisting? Where in the code?
Appendix
475.
appendix
475.
35.
34.
475.
34.
34, I beg your pardon. 34. 475. Here also, my lord, your lordship, can you see? The circumstances given, I have also pleaded that the circumstances is not following my case. If your lordship sees that the division officer shall report to the chief engineer if in his opinion of above wrong has been committed by the contractor on receipt of such report of the divisional officer, the chief engineer shall make an inquiry.
According to this, the contractor has not been defined or defined.
My lord's contractor has been defined. My lord.
Defined.
Contractor has been defined and the persons who is working.
Yes. Now I got it. That definition in 7.
7, man.
I've got it.
So now, my lord, here it says, even if this is made applicable in principle, it says that the chief engineer has to make an inquiry, post that he has to issue the notice, focus notice. Now, the lordship can have the first focus is up to at page 2032. This says their blacklisting focus and I have not replied. The lordship can have that page 32. This is their first focus notice, they say. I don't say it's a focus because it simply states the facts and no inquiry has been contemplated. They try to snatch away the important files from the estimates so and so. The contract case has been registered. Therefore, you explain. Now, my lord, the inquiry as per the act, as per the rule.
You were forwarded to jail.
Yes, my lord. I forwarded. That is the third part I will ask. I come to my why all these things happen. Now, my lord, can you see the focus for blacklisting at page 33? As reported by the Superintendent Engineer Mechanical Division Bhubaneswar,
No, same thing is a reflection.
No, my lord,
Snatching of a file.
No, my lord, here they say, the total incident was recorded in the division the division office camera. My lord, I will not going to contest anything because they have submitted the
Correct. So if it appears that you have snatched the file or you have done anything or
I have no defense.
So that is what you said.
Yes, that's what. Now the question is why these things have happened to me. That also I have explained in my SOCUS. And that's my third part of argument. You'll also can have my page
35.
38. Now 35 is the SOCUS started. 38 with the individual persons who are in there. The chief engineer, the estimator, Lordship kindly have the first, the complainant is the estimator Satyasri Mahapatra, of whom I have filed say paragraphs 2 of that against him and said.
No, you have said that this is really a fallout of all these. You were a whistleblower. You have.
On record, I have put in.
That's true that you flagged several issues of malpractice, corruption, and that is the reason you have been entangled.
And in each one events that there is a criminal case is pending. Now
Okay.
that is how the persons who is actually against me, I have been adjudged by them. That's number 3, my lord. Now your lordship can see the impugned order. The SOCA says, well, I'm just very grieved. The SOCA says that the SOCA's allegation is that I tried to snatch away the important.
Oh, I have already read, sir.
Well,
Where is the order?
But the order, your lordship can see it is a complete improvement. Last paragraph at page 20.
Page
20.
20.
Yes, madam. The Chief Engineer Mechanical Water Resources Department has acted in terms of the report of the Executive Engineer Mechanical Division, Superintendent Engineer Mechanical Division. Upon consideration of the reply, vis-a-vis the report, Arthur had entered into the department beyond the office hour, misbehaved with the staff. My lord, here onward, assess the ongoing tender.
No, that you say that their allegation was that you have gone there to snatch the file, but in the findings they have said that you have gone to say misbehave with other peoples and then.
Says the confidence, and that's what never been charged. That is what I'm.
Oh, I understand that you say that this can't be a ground which is dehones the show cause.
So,
I understood. Say in one word, sir.
well, that's only
Say.
recapitulating the entire.
That's
Obliged.
yes. Consider.
If I may be allowed to respond.
Reply to reply.
My lords, these submissions were.
I do not know.
My lords, these submissions.
You
were
have
not-
already said, let us see, we'll see to the file.
And actually, out of 5 years, I have already
Sorry.
scored 4 years.
Yes.
My lords, only request.
Yes, call the name.
Item number 2.
Obliged.
In item 2 on the last occasion, you have directed the state to file that.
On behalf of the registry of this honorable court, I received the Paraway's comments day before yesterday. So I filed that order passed by the.
Do we have the roster? Do you have the roster? Does it come?
No. Situation.
What is the, no, I have been told that there is an assignment given to us, this bench.
And that is because the fact that Honorable Justice K.R. Mahapatra was a member of the appeal committee. Therefore,
Yes, what is what is the fact?
the fact of the case which your lordship was also pleased to take note of on the last occasion is with regard to initiation of a proceeding with regard to missing of 5 files, 3 of which were discovered subsequently, 2 of which were reconstituted, and all the cases have been disposed of. Though they take resort to section Rule 15 of the Civil Service Classification Control Appeal Rules, no supply of the inquiry report was made, which were done after the punishment was inflicted. That is why your lordship wanted the state to file a response to that.
File your response. Yes, sir. You have filed your counter?
The counter I have received day before yesterday, I have received the otherwise comments from the. Actually, also. 2 weeks. No, 1 week time, 2 week time. 2 weeks. Submitted to Mr. Das. That he has received the otherwise comment yesterday, day before yesterday. Which are required to be put in the form of an affidavit.
Maybe talking to about that. Just of Niagara district and the IAC
They have to
Where is-
pay me the
where is
balance.
clause-
My
Sir, where is
designate-
clause 11?
Yes, ma'am.
Which one is clause?
It is not
Page
accurate.
27.
No, my photo.
Look at the page 27.
Last time, my lordship has asked me, government to adopt in
Yeah,
instance.
then where is clause? What is this? Clause 11 is any other reason attributable beyond the control of the. This is the clause 11. Page 27 if you count, brother. Oh, 27. It's no 17 as per clause 11.
Agreement.
Oh. Where is clause 11 of the agreement, sir?
My lord, that clause 11 of the agreement, I have not, but my lord, subsequent letter.
No, no, sir. That is a reason which is assigned in serial number 17 that the work may be closed under clause 11 of the agreement.
Yes, sir.
So,
That part has already been closed. The matter has already been closed.
sir,
Only they have
I
to return the
understand.
money.
Sir,
Only
sir,
come to pay 36, my lord. Pay
page
36.
36.
Yes, sir.
Mr. Jana.
The agreement, last
Mr.
part,
Jana.
the agreement with the agency has been closed and the total expenditure of.
Mr. Jana,
Mr.
Mr.
Jera,
Jana,
please.
you have enclosed Annexure 1,
Yes, ma'am.
the cover page of the agreement, if to come.
Yes, ma'am. Cover page of the agreement.
So unless we see the agreement clause 11 in verbatim,
In that respect, my lord,
you have not made that agreement forming part of this reproduction, at least the relevant page of that clause 11. We are unable to.
then I'll kindly annex page 21, annex 5.
Sir, we wanted to know, sir, what is that clause 11 of the agreement? Are we not entitled to have a glimpse of that?
Yes, sir.
When authority has said that it is closed under clause 11, then we have to see what is that clause 11.
Then I have to file the enter contract.
So you please show us.
Yes. Then when
Have
the
the copy of the agreement, madam.
clause 11,
The impresses is.
No, I understand that once the delay is not attributable to his conduct, then he should not be saddled. That is what he wanted to. I understand. But what is the clause 11?
Claims interest, claims the legitimate dues.
So we have to, sir, without looking at clause 11, sir, we can't.
my lord, I'm in a virtual mode. That's why I'm unable to produce before the agreement, entire agreement.
But do you have the copy of the agreement with you, sir?
Yes, my lord. Yes, I'm a
Can you read clause 11 on a virtual mode?
Yes, my lord. I will.
Can you read? Please read clause 11 of the agreement, sir.
Yes, my lord. Clause 10, clause 10. In clause 11, my lord. If at any time after the commencement of the work, the government of Orissa shall for any reason, whatever not require the whole work thereof as specified in the tender to be carried out, the engineer-in-chief shall give notice in writing of the fact to the contractor, who shall have no claim to any payment or compensation.
I could not gather it, sir. Frankly speaking, I could not gather it. What you are reading,
Yes.
I think the voice is a bit blurred.
Then when I
Come
will
closer.
I will
Yeah.
find the enter the agreement with
To file, yes.
Yes,
after noticing, after noticing the fact that the who is the chief engineer executive engineer, I find that clause. This is the signed by executive engineer. Executive. Executive. So that is what I said.
28th.
Item
Yes,
number
28.
8.
Huh?
Item 8, sir.
Item 6.
What 6?
I mean, BC
Just wait after that. So you miss the mark. Others are waiting. Let them. Let them. Item number 8.
Milord, I am in BC, Your Lordship, I beg pardon, Milord. Milord, Your Lordship directed on 8/7/2025 and yesterday also Your Lordship directed to the Government Council to file the affidavit.
Page 30, page 37.
The file. Give the files. In tender matters, it is better to have a physical copy.
Madam, only defect which we have pointed out. The page 37 whether was there,
Lordship, no, your lordship, that page is not there.
filed that.
Page 37 was not there. Sir, you have got the copy of the affidavit, sir?
No, Milord.
You have not received the copy of the counter affidavit. You have
No,
disclosed.
Milord, no.
Page 37 is not there.
Your Lordship, I have not
Sir,
received
there is
because I am
a
in BC.
echo which is coming out.
Milord, I have not received Your
We have
Lordship.
specifically stated in the stand, madam.
Your lordship.
Can we have the glimpse of your opposition, this counter? No, counter can, why it has not come?
No,
Oh,
this-
today morning, the recorder submits that the counter affidavit has been filed today in the department. What is this?
Hard copy.
Oh,
He filed it.
whatever is filed. This is the physical.
you take instructions in that?
The request of this matter. Such matter to peruse the
MESTA.
Can I play for a passing?
God. Why? Argue the matter, you get an opportunity now, today.
I leave next to she is on her legs.
file is there in front of you.
Is it?
Not on the unit. Let her come
You are the advocate on record.
for tomorrow.
You are the advocate
Yes.
on record. So you have prepared it. You should know. You have read a brief when you drafted.
Let it come tomorrow and I will place the note.
You will argue.
Yes,
Yes. Tomorrow he will argue. That's an undertaking you have given.
minor.
Yes.
Item 11. Item 11.
Sorry, Lordship.
11 open.
Small mistake there, Lordship, at the outset I want to.
11
Wish to
open.
that Lordship. In prior personal Lordship, instead of answer 10, it is written
11
15 Lordship. That the lease deed is. Lordship, annex of 10, but wrongly, this is my mistake, Lordship. And sir,
Leave to-
is,
Here. Can we repeat one? Yes. Forget about it. These are the.
Grateful,
No difficulty.
public litigation, Lordship.
Public interest litigation.
Lordship, the first instance I had approved.
All the leases for mining you wanted to be scrapped.
In fact, Lordship, yes, lots of illegal, lots of people, lots to enter the purpose of the section 27. It is only for the account of the state revenue, Lordship. It overall reading, Lordship, rule 27 speaks out. It is only for government revenue. And by this process, Lordship, by this process, Lordship, we will, the government, state exchequer should be protected, Lordship. That is our entire purpose. And by this activity, Lordship, they have ignored
What
every,
activities?
Lordship, by this action procedure,
Auction.
action procedure, Lordship.
Oh.
Rule 27 gives it from hands to the officers for going for action of this, Lordship.
Correct.
So that's Lordship. And there are certain principles laid down under Rule 27, Lordship.
What are the principles?
Lordship, kindly, just
No, just give us a broad idea.
Lordship, what would be the, how they will come up with the wide publicity, why there will be a wide participation, Lordship.
Yes.
And they have given emphasis on the, Lordship, highest bidding
Correct.
and acceptance of, that's why, but here,
That is what is the main motive. Why the auction is done
Yes.
to secure the highest price, the best price.
so Lordship, single bid has been avoided for the, Lordship, on the prior facie. That's why, Lordship, in number of judgments, Lordship, laid down, and Lordship, the law is very clear.
That is also we are concerned. So this single bid, is there any provision for a single bid?
Whether where the single bid was considered, if at all it was considered, Your Lordship.
Disclose the facts.
Two persons participated, out of them one was not accepted. Accepted, no single bid, Lordship.
Accepted means on what ground?
On technical is disqualified, Lordship. So those remains single.
File affidavit. Affidavit to be
Annexure
filed.
2. You are relying on
Plus,
Annexure
plus.
2.
Plus.
This,
This solitary point which is raised in the instant public interest.
Let's.
Yes. 11th. I just recorded a submission. That is a single figure slogan. Well, same.
check is rejected.
The first is this. I have the docket case submission. So the council for the prisoner further points out that there is a typical topographical mistake of the instance of petition. So in semicolon, instead of annexure 10, it is recorded as annexure 2. That mistake is ministerial in nature. And we do not feel that that is substantial. Yes.
Item number 12.
Short point. For one cause of action, double penalty was.
I am very apprehensive of a short point, sir. Sometimes it becomes so big.
But no short for LRC. But one cause of action, double penalty is imposed by under the OMMC for one cause of action.
What is this OM?
Some mineral concession rules. Mine the mineral concessions rules. So I deposited them all. So thereafter, the district level committee imposed again the same punishment. So I approached the appellate authority RDC.
For the same offense.
For the same offense, man. So RDC, the measure is that the former Revenue Divisional Commissioner heard the appeal on merit, and in open court expressed that appeal is allowed. But suddenly at night he was transferred to State Election Commission, so he could not pronounce judgment. Former RDC. So I again appealed for the present RDC and submitted that the earlier fact. And in spite of my repeated request to the present appellate authority, my Sairat appeal 1/22 is not yet been taken up. So I am requesting your former the predecessor RDC.
That is not a ground, sir. That is not a ground for dismissal of an appeal.
No, not this. My appeal is not dismissed.
I'm giving you a very example of the court. The matter was in a different bench. At the time of an argument, the bench must have expressed something, interacted. Then the matter is listed to another way. Does it mean that
No.
your observation is
I am
binding?
prepared to face the appeal.
Different bench will take his own.
Yes, my
decision.
due obligation. I am prepared to.
So only thing is disposal.
Yes, simply clear.
And what is this? PIR.
No, PI.
Uh.
The affected, it's really the
Because
affected.
I am grappling with this kind of a situation here. Why you not? For that, the person has to move to the court. I'm really surprised. I think I have been noticing since last many years when I switched over my position from that side of the room to this side of the room. 80% litigations are that. The authorities are not taking up anything, they are not deciding anything, they are just sitting tight over the matter. And it is a court who is constantly passing an order and reminding them of their solemn duty. That please, it is your duty to dispose of, you are not disposing. Courts are not meant for that. Why don't you give an instructions when you are appearing that dispose of?
Yes, yes, well, page, after this order, again I filed a petition, annexure 7, page 24, on 23, yes. Thereafter I filed a petition. Liberty was granted to me to approach the RDC again by filing a fresh application. So, in obedience to the order, I filed a petition on 8/2/2024 in spite of the order.
I will intimate to the other.
Why? He's the same officer.
Same, madam.
No?
Same officer.
So why not we call this officer to appear before us after noticing this order? If he does not have any kind of allegiance or a respect to the court's order, why not? We'll suggest or recommend that he should be put to task.
Yes, Your Lordship. I will seek instructions, Your Lordship, as to why this case.
You are directing him to appear. Who is the author?
My lord, Revenue Divisional Commissioner Central, Qatar.
Let him appear. Who is he's a single man?
Single.
Lordship, I will come back after lunch, Your Lordship. I'll intimate to the RDC as to why this has happened, Your Lordship. I'll come back at 2.
When my brother was on party today,
Yes, Your Lordship. I
the
agree, Your
request
Lordship.
was made that you dispose of the matter. He was permitted to make an application. And despite that, he will not. And this is what is in the month of January 2024.
Yes, Your Lordship.
Now
I
we are
will
in
make that
25,
application
2025.
on 8/2/2024, Your Lordship. I will find it.
It was January 3rd, 2024 is the date of the order.
There will be shorter span of time, it would have been different. We would have
Yes,
accommodated.
I agree.
We were awfully busy.
I understand.
I agree. This is
One and a half
beyond
year.
a year, Your Lordship.
This is not expected.
1.5 years, Your Lordship. I will come back, Your Lordship, by 2 p.m. If I can.
We have mentioned appeal number also.
Yes, Your Lordship. Tomorrow, Your Lordship.
Let him appear personally.
Tomorrow I will seek instruction. I'll come back, Your Lordship.
Let him appear. Why he has not? We are going to initiate a suo motu proceedings for country.
One last chance, Your Lordship. I will come back tomorrow. Why this?
This is not expected. It's not expected.
I understand, Your Lordship. I understand, Your Lordship. I will intimate to him, Your
I'm
Lordship.
thankful to my brothers who has invited this attention. I did not really notice that. And that is the irony of the paperless, because unless you go and click, you will not be able to see.
Tomorrow I'll be there, Your Lordship. I will instruct him as to why he has not disposed.
only as.
Just address what,
Yes, sir. On the top of the curriculum.
To be mentioned.
Yes, top of the legend.
Under the heading to be mentioned, but we have to.
yes,
Tomorrow, sir?
let's let another question.
Yes.
Item note 13.
Yes, madam, what is the grievance?
My lord, this is a grievance that this tender which was floated, my lord, the condition has been made, tailor-made for one bidder keeping in mind, my lord. This is the fact of the case, my lord.
In this condition, sir, we have to meet. It's been saying that these conditions are tailor-made conditions. Just to, help or assist one person.
That I can substantiate, my lord. The fact is, the veterinary medicine
Give me that.
pays 33, my lord.
Similar,
Yes.
we have.
No, my lord.
This.
Your lordship disposed of,
22-23.
your lordship
There
disposed.
was no standard.
Yes.
Said,
Your lordship remembers. Well, that disposed of. Now they have, your lordship disposed of that in 2012. That order is there. That is in vacation. And now they have come, no, this is everything is right. Well, let me place the case for them.
What is the case for?
There are 60 medicines, veterinary medicines put under tender because on public auction, my lord, that is, they have given one, my lord, one condition as pays 43. But that condition says the bidder must have 3 years experience in, my lord, pays 43.
It has already expired. Now, have you opened the technical basis?
So they have extended, my lord.
Your case was out of experience of 4 years or 5 years. Out of them, 3 years fell within the period of Corona.
No, my lord. They have never floated any tender. They have not-
There was no tender.
Tender.
So
And they are saying now you have 3 years because he has given somebody the fact given under Act. They have chosen one bidder to supply without fresh tender. And he has supplied 26 crores rupees of medicine without any tender, my lord. That is my allegation, my lord, that your lordship kindly see page 131.
Now they have floated a tender, sir. Madam.
My lord.
Now, then what is the difficulty? What you say now, what they did,
No, they have extended the date.
what extended the date?
The last date of submission now extended to, my lord, 28th July. And this is
28th July.
July.
So let them conduct the bid there.
My lord, because only one bidder is,
How do you know there is? only
because
one?
my lord, that is my case. I will.
Please consider,
Right.
they have extended the date for submission. Like you can't say there is only one bidder because somebody may come and file its bid on or before 28th of July.
My lord, that is a defective tender. That is my case before your lordship. It is not in accordance with rule.
What is the defense?
OGFR, my lord, I have annexed OGFR rule of Odisha. My lord, kindly see OGFR. OGFR rule, I have entirely annexed the OGFR rule, which says, my lord, that how to procure the fundamental principle of public procurement 135. That's your lordship, just hear me for 1 minute. Hello? My lord, your lordship, for hear me for a moment. 151, my lord.
What?
51, the page. Contents of bidding documents. This is OGFR rule 2022. My lord, the last paragraph I am saying, the model bidding documents. My lord, sorry. My lord, the model bidding document for procurement of goods published by department. La- 151, last paragraph.
Yes.
The model bidding document, how to contain the bidding document, that is there, but the model bidding document for procurement of goods published by Department of Expenditure, Ministry of Finance, Government of India as available such and such may be adopted. My lord, that is what is that model tender document I have given at page 153, annexure 9, my lord. Kindly see. Page 166. 166.
166.
My lord.
Yes.
That is, open the tender, my lord, tender type, open tender, domestic, form of contract and item rate. 60 medicines been tendered, but no item rate has been specified. Second, my lord, 2.0, requirement of details. The bidders may submit bids for any or all the schedules. However, he must quote for the complete schedule that he quotes for without exception, part quotation allowed or not. But this is 60 medicines they have tendered. Their tender says 60 veterinary medicines, but EMD kept 80 lakhs. I may supply 2-3 medicines. I may not supply 60 because I am a distributor, I am a manufacturer. So I may supply 4 medicine, but I have to give 80 lakhs as EMD and 2.5 crore as government supply. I must have experience of 3 years. That is my lord case. I am saying the same MD in the HON'BLE, Orissa milk production, my lord. My lord, I have given 2 tender of the Odisha government. It is in accordance with this model document. My lord, kindly see the HON'BLE document. The same officer, the same OS officer, the same IS officer is MD, and my lord, page 203. Supply of cattle feed. And everything has been 201, my lord, sorry. There is active cooling box with DC compressor EMD value stated. Kidney tray EMD value stated. Tracing table for small animals, everything. And every item's rate is also specified. Now they have come up with a tender which is not in accordance with the OGFR rule 2023. And the EMD has to be, my lord, another point, as per the OGFR, EMD has to be 2 to 5% of estimated value of the goods to be procured.
Where?
Page 133, my lord, 212. Clause 1. To safeguard against a bidder's withdrawing or altering its bid during the bid validity period, in the case advertised up to bid tender inquiry, bid security such and such, my last line. The bidder should have asked to furnish the bid security along with their bid. Amount of bid security should generally be between 2 to 5%.
133.
My lord, page 133.
Which clause?
212. Bid security.
Yes.
Last line, my lord. Clause 1, last line. Amount of bid security should generally be between 2 to 5% of the estimated value of the goods to be procured.
Yes.
Well, they have not estimated the
What estimated value of the procured.
Procured.
That is an EMD is this money deposits.
yes,
So that should be the 2 to 5% of the estimated value.
estimated. My lord, they have not stated in the tender what is the estimated value of the medicines and how the tender should be.
How estimated value of the medicines can be in those tenders also it is not indicated.
Yes, my lord, that is there.
Which you refer.
My lord,
It's
that
all EMD which is done.
my lord.
Is an EMD means unless money deposits, they have to
They have
show their solvency so that in the event they back out, they can definitely seize those.
my lord, page 206, my lord, kindly see. Page
So you
206.
refer 201.
Oh, that is first tender.
That is the EMD. It's
My-
not the estimated
My,
value.
my lord, 206, kindly see.
Yes.
206. Tender are invited from manufacturing units, mill owners, traders, my lord, whatever I turnover. That is de-oiled rice and the bidder minimum turnover is this and EMD
No,
for
that is
each.
what the criteria they have put, but estimated value when you are, nobody can estimate that what should be. They say that beyond that we will not.
So on estimated value, the EMD has been fixed. My point is this.
No. There may be conditions that you'll have to pay this much of an amount as a GMP.
Well, that is there.
So
But
instead of 2 to 5%, they must have said that this is the amount you'll have to pay.
well,
You have to deposit.
that is there always. My case before your lordship, that is there is 60 medicines to be procured. I will give 3 medicines, madam. I am eligible to supply 3 medicines. So I have to give, and who will supply 60 medicine will give 80 lakhs EMD, and who will give 2 medicines, they will give 80 lakhs. So they want the potential bidder should be eliminated. My lord, my thing is before your lordship, because my lord, kindly see the order of this honorable court, that is I am annexed, and it is a elaborate order. They have directed opposite party number 1, but the opposite party number 2 director who has floated the tender
Is it that one person is to supply all the types of medicines?
Not necessarily.
All the 60. If suppose a bidder is successful, he will to supply all the 60.
If he is successful, then he will supply
All the 60.
If he is successful, there cannot be any loss. And the judgment, my land.
Whether there is a clause, I know about some of the contracts or these tenders. That below a certain quantity or the amount of amount, the tender is not floated.
Yes.
The tender is only floated above that
Above that.
particular amount.
Yes.
Correct.
Yes, ma'am.
Is there any cap
That I'll have to.
in the state? No, I'm telling you, she's raising an issue. The
I
answer is
understand.
this.
I understand.
The answer is this.
Yes.
What she is proposing, I do not know what will happen to that. There are 60 items which you have
I have
floated.
from
Now there will be a 60 manufacturer
Yes.
or a 60 dealers who can apply for tender. It will be a humongous task
Yes.
for the authority to
authority.
tackle 60 the contractors. And if we go by this, then each of the item may not exceed the particular limit. Say when you say the liver extract without VITB, the quantity is say 1,50,000 means bottle of 30 ml. It may not, this price may not exceed that barrier. So please consider in that light. You understood what? He's saying that I can apply for 3.
Yes,
I
I
cannot
understood.
apply for all 60.
So why should I pay that much amount?
That is what.
Yes,
That's
I understood from her, sir.
that is what one has to understand. Whether that is permissible.
Your lordship be kind enough to call it next Monday or Tuesday.
Please consider, madam, also you consider.
Well.
Because if somebody applies, when you say 3 items, I'm going more conservative for each item.
Yes, yes.
So for 60 items, there may be a 60 different, the bidders for each item. What will happen?
Government has to pay less, my lord. It is our money.
Sir, the difficulty is,
I do understand, my lord.
I am very apprehensive.
My lord.
If we accept this,
My lord.
you are talking about 3. Why not 1?
One.
My lord. That's the item.
Yes, if the amount of that quantity does not cross that particular barrier, that up to this amount, no tender,
No, my lord. That's right.
that would further encourage the nepotism because
Yes.
they will go with those
They have done
those
it.
bidders who are registered one supply
My
without
lord,
any
they
tender.
have done it at page 132. That's I'm
It is
giving.
better that once the amount is accumulated, then at least the competition is invited.
Yes, they're now avoiding
It goes
that.
against you, madam.
But that now avoiding competition, my lord. In the district level, we are supplying.
Madam, please understand, sir. Probably I could not make you
Yes, yes,
understand.
I do understand.
No, you do not.
Sorry.
You are saying at one hand, let us see, you are saying that these 60 items are clubbed together
My lord.
just to make other eligible persons who otherwise are competent to supply some of the items
My lord.
not to participate in the tender. So they wanted to rule out.
Yes.
Correct?
Yes.
Accepted. Suppose
Right.
if they permit the bidders to apply for 2 items, 1 item, 3 items, 4 items out of 60. So he will bid only for 1 item.
My lord.
The amount, the estimated value which you say the of that item is hardly 2.5 lakhs.
Exactly.
No tender, because the policy is no tender would be floated if the estimated value is less than 1 crore or 2 crores.
Yes.
So after all, this is the requirement. They have to purchase it. Then how they will purchase? From their registered suppliers.
Suppliers.
Straight away giving an order to them to supply. That also goes against the spirit.
That's in that.
Then indirectly encouraging
That's my.
the nepotism
the favoritism. So madam, from both the angles you have to consider.
Yes, my lord.
You are taking a plea, but it is a double-edged sword.
I have
Double-edged sword.
I have annexed the documents when there was no tender and district authority was procuring.
You are talking, you come with that. If you can also say that what is the policy decision, the value, you also consider this value of each of the item, estimated value. And if it falls short, no difficulty.
My lord, well, just one
No difficulty.
my lord, just for a moment, my lord, they have decided.
When
1 week.
you have extended the date of submissions.
Yes.
You come before
There is no
28.
problem. Yes, ma'am.
You come before 28.
Yes, ma'am.
When
25th.
25th come. The challenge is made to
Item number 14.
Minor
At the earliest, therefore ensuring supply of safe blood, my lord. In the
So you want to say that every blood bank in the state must
actually the honorable
this testing
yes
before it is
supplied to anybody. My lord, kindly both
administered to any of the patients.
yes, my lord. My lord, actually in another polymer chain reaction. I want to draw attention of the honorable court. My lord, kindly look at page 11.
Let them say that if it is an order of the day, then in that event they have
My lord,
whether they are doing or they are not doing.
we are doing, we have submitted for your lawsuit in another case. That by March 2025, we are trying to have the facility each and every block. That has not been complete.
My lord, on 30th November. Yes,
Yes.
there is judgment. My lord was also a part of the bench, my lord.
So why you are multiplying the EIA? If there is already an order in the EIA.
There is an order in the PIL, my lord. This is a contempt petition, my lord.
For contempt.
Contempt petition, my lord. So kindly,
File your affidavit, that's your valuable right.
my lord, actually,
Sir, in a contempt jurisdiction, first they have to give an explanation.
Yes.
Why they could not implement the order.
yes.
After that, if we found that their action was willful and deliberate,
Yes,
then we will issue a rule why the contempt means why they should not be punished.
yes, ma'am.
So this right to defend is the very valuable and constitutional right.
Yes, ma'am.
Let them file their affidavit to the contempt. And thereafter we'll see to it whether the explanation is correct or not.
Yes, ma'am.
So let them file. How soon you can show?
3 weeks. Right.
This matter is pending. 2
I,
weeks,
I,
you do it.
I,
2 weeks, you file 2 weeks. This is an application
as a matter of
for
fact,
contempt, alleging the willful and deliberate.
they only express that difficulty about 200 crores requirement.
He's highlighted.
Yeah,
What steps have been taken and where it is tough. There is no.
Yes.
difficulty.
Right.
Yes.
It's all about the.
It's possible.
Ma'am,
Yes, ma'am.
Pastoral matter item number 6.
That is what is required. That's why we want as an.
Please, I am in the virtual mode, my lord.
Item 6, sir.
Right order of your lordships on 7/2025. And I was given a liberty manner to file, we did the mining officer as a party. I have filed one IA matter, that is IA number 11934 of current.
We are allowing this.
119.
This is a petition seeking inclusion of the mining officer.
Mining officer and also the deputy director. Mining officer.
On the board. When you have filed. When you have filed.
Today morning.
Okay, it comes. This tomorrow. Let it come. What of the boards? Maybe. Have you got the copy? Not on the. Tomorrow give it on board.
Today they have filed.
Today it is the morning they have.
Yes, yes.
Yes.
Monday.
Yes.
Come on.
Item number 15. Pastoral.
My lord, item number 16. I may please, I am in the virtual mode.
Item number 16.
Yes, my lord, I may please, I am in the virtual mode, my lord. I may please, my lord, I am in the virtual mode. Item 16.
It's an order, this is a petition, your lordship, challenging the recovery of demand more than 20% under the Income Tax Act, your lordship. I was initially assessed under 143 and I have preferred an appeal, Your Lordship. Pursuant to the order of assessment, a demand of rupees 1 crore 35 lakhs some odd has been raised, Your Lordship. I have preferred an appeal. The said appeal is pending. It is not disposed of, Your Lordship. While the said appeal was pending, Your Lordship, I have preferred a petition under section 220 subsection 6, praying for stay of the balance of the demand. While disposing of my first, this is my first stay application, Your Lordship. While disposing of the said stay application, Your Lordship, the authority said that you pay 20%, that amounts to rupees 27 lakh of the entire demand, disputed demand, and subject to such payment, the balance demand shall remain stayed, Your Lordship. Thereafter, Your Lordship, by several memos, by several challans, I have made payment of 16,91,000 some odd rupees, Your Lordship. I have paid.
Within the constitution.
Yes, Your Lordship. But there was a direction for payment of 27 lakhs. I could not pay. I have paid 16,91,000, Your Lordship. Thereafter, I preferred a second stay application, praying for stay of the balance demand, that is 1 crore 18 lakh, Your Lordship. The authority, while disposing of the second stay application, Your Lordship, has said, again, taking into consideration that yes, 20% you have to deposit as per the CBTT circular. So again, taking into account as if 1 crore 18 is the balance amount, again 20% on that, and said that you have to deposit further 23 lakhs. They have not taken into consideration the 16 lakh 91 that have already deposited. While the fact remains as such, further, I have deposited 6,77,000 rupees. So in all, 16 lakh 91 and 677, almost, Your Lordship, 23 lakhs are deposited. Thereafter, there is a refund of 5 years that is there in my favor for AY 2021, 21, 22, 22, 23, 23, 24, and 24, 25, Your Lordship. That refund again is substantial, Your Lordship. The said refund has been adjusted without affording an opportunity under section 245 that says that any demand which can be adjusted, before that an intimation has to be provided. The said intimation has not been provided. In all, Your Lordship, almost 48 lakhs has been appropriated against the said demand of 1 crore 35 lakhs, whereas the 20% comes to 27 lakhs. My prayer is that over and above 20%, whatever has been appropriated, the same may be refunded, Your Lordship. That is my prayer.
To make that prayer before the authority.
Your Lordship, the appropriation has been done, Your Lordship, in violation of the circular, Your Lordship, by the authority, Your Lordship.
So have you approached the authority that how you can do it?
Your Lordship may kindly see.
So. In this case, the demand has been stayed as per High Court order also in case number 77. After that, before that, prior to that, Your Lordship, the return has been processed by CPC. And before adjusting any amount against the demand, they issue a notice or intimation under section 245. And that can be seen in page number 71. Before adjusting any amount, they issue a notice. If you didn't comply with the notice, the system bound computer system, automatically after 21 days, the amount has been adjusted. This is the only issue.
Your Lordship, that is the intimation that I have annexed. It is provided for 1 year only. That is AY 24-25. For rest 4 years, there is a clear averment also that I have taken in my petition. No such intimation has been provided.
I have to verify for that year, but
But it appears that she may not have, and what this amount she's agreeing that you can do it, it will cover that 27 lakhs.
Yes, Your Lordship. Over and above 27 lakhs, I am praying for refund. That is all. The appeal is to be decided on merits, Your Lordship. 27 lakhs is.
How can you get it? If your CBTT circular saying that beyond 20.
Your Lordship, what I want to say, we issue intimation. I'll be verifying and having instruction about
your intimation. You can adjust the amount, but here
it's a system bound which is maintained by CPC, Central Processing Unit at Bangalore.
Don't apply your mind. Then you mean to say that you don't apply your mind. Then why is there authorities?
Now the processing
Required.
now
Because
what system now this
now it will be taken over by AI, artificial intelligence, everything has to be done. No human intervention is required. Everything is to be done in this way.
Your Lordship, CBDT circular that my learned senior is relying upon lays down two conditions, Your Lordship. One, where earlier there was a condition that 15% is to be deposited, subsequently it was partially modified to 20%. So 15% it says once you've deposited until the disposal of the appeal. So there is no provision to collect further. And there are instances, but those instances have to be cited while collecting more than 20%, Your Lordship. Honorable Delhi High Court has also directed to that effect and said that any amount that is taken beyond 20% has to be refunded with interest.
Yes, what we wanted to know from them. No, can it be done?
Your Lordship, I'll take instruction in this.
Instruction come on Wednesday, next Wednesday.
I'm not sure for 2 weeks.
This
I'll take-
petition is filed much earlier, Your Lordship. It's a copy also, sir.
From yesterday, I have been grappling with this situation. I invited the attention of the government advocate. We can clear on that. Give explanation. Take instruction.
Is passing the
Oh. Okay.
Right.
Where.
Sir.
Yes. Positive.
Item now 22, sorry, 23. 23.
Mr. Rescuer, kindly place my thought at Tuesday.
Item now 24.
Item 24, Your Lordship, I'm on VC. I'm praying for 2 weeks' time, Your Lordship.
You are for? Yes, sir.
I am for the petitioner. I'm praying for 2 weeks' time, Your Lordship.
Next time.
Item 25.
May I please? Register signature.
Yes.
26.
26 of September.
Item now 27.
The 27 pertains to cancellation of registration.
Item 28.
Item 28, Your Lordship, is also registration cancellation matter. I have already given the order. Obliged.
Item number 29.
We are on 38. But I didn't see the petition. They have not served the copy yet. But 3 people are on 38.
Please for the appellate.
I think I see
This is
name of
party is
This was department.
Mr. Tripathi, I think Mr.
Yes. One is a good.
Matter which the board decided that you take your seniority on the date you enter the cadre. Your principle of Supreme Court. So, that order is under challenge.
Oh, he's with you.
He's
The way he rushed and thought that he was the appellate.
but
What to do with them? They are not the software of the thing.
It is also there. We have entered on caveat.
Oh, she says that 3 of us is on caveat.
Malone.
Copy has not been served. Now they are not here. It's a Passover.
Or else, call it some other day in the meantime, with my learned friends.
If they are not, who will communicate that? If they are present, then the order can.
Yes, sir, I have.
Service.
Malone.
At least I can communicate to Mr. Samir Kumar Das, in the second case.
You can make a communication.
we'll try to inform Mr. Tripathi.
Yes.
He's also with us. Yeah.
He came rushing straight. He came rushing round circle, completed a something on that kind.
Without the appellant.
Yes, Passover.
Item note 30.
Permitted to withdraw, madam. I already. Please.
Yes. Item 31.
The restaurant related to after launch.
31.
31 memo for withdrawal is there.
31.
Who is there?
I'm from the withdrawal of the.
I'm sorry, I'm sorry.
I'm from the department. He's in the wrong page.
I'm on 33, I'm sorry.
31, sir. It's for
Oh,
withdrawal.
he's in a right file, not wrong.
Wrong serial number.
Sure.
What can be done? He's not here. Please go.
Item 32.
Can it be after recess, ma'am? 32.
Right.
31 million permitted to.
Yes.
Give your name. Recorder is there.
My power is.
And another one is one.
Because it was on that time, 45.
Yes, sir.
Yes, ma'am. M service there.
32 item, 5 was not there.
The petitioner is not, oh, we
No,
got that.
I'm, yeah,
There is a delay application.
yes.
Have you served? Notices have been issued on a delay.
Yes, my lord. 19/6/2025.
Yes,
19/6/2025. Is the order
yes,
directing for issuance of notice on the question of delay.
yes. Has it been served?
My record shows it has been served.
Yes, ma'am. Yeah, pure. Soon respondent and pure.
Here.
I am on behalf of the respondent. We have received the letter.
Received the letter.
Received their petition, readable petition.
So what do you want?
Actually, I am praying for one Passover.
Not today then.
Right.
Let it appear on Monday.
Right.
Yes.
It's okay.
Who is there?
Item note 33.
Who is the second slave?
Sir.
Yes.
Item 33.
33 receipt, after launching a.
So you are on the right way.
Firstly, I'm sorry, I was on wrong serial.
It's a matter, your lordship will remember, state has been taking time last 2 days. Last occasion, my lord, Justice Raman observed that you comply with the judgment and come back. That's regularization, Lord, on the point of discrimination. And your lordship judgment, Amar Kumar Nath versus State of Orissa, covering the whole issue. That's a short point.
So what the state is taking a stand.
State last occasion, your lordship directed the London State Council to come back, of course, without writing any order, comply with the judgment and come back. Granted them sufficient time. Before lordship will see, your lordship judgment para 36 covers the point. Amarnath case. Arun Kumar.
Say, who is appearing?
Can be disposed of referring to Amar Kumar Nath's resume.
Who is appearing? Mr. Rudra Narayan, Orija.
We are for the respondent here.
Sastro, my uncle Sastro.
Say.
But he is assisting me.
Oh, and apparently Shashwat Das.
Yes, that's.
To come after this,
Yes.
let him come.
Right now, let it.
BS3.
Mr. Das.
Yes, ma'am.
For the respondent, but
In item 29.
Mr. Tripathi is on.
Oh, please see. Yes, ma'am. We have entered cabinet.
Mr. Tripathi. Mr. Tripathi, in that matter, there is a caveat why you have not served the copy.
Today itself, I will serve.
Yes, serve the copy and we are fixing this matter in the next week
Ma'am.
or next
Madam.
Tuesday.
Well,
Wait,
Serving the copy.
wait.
yes, ma'am. Item 33.
33. Give me a file.
State is not that. That Arun Kumar judgment, so the Lordship had directed me to take instruction from the authorities whether the those for the petitioner to be regularized. That Arun Kumar Nath judgment, your Lordship.
Yes.
So here is a case where the petitioner was initially appointed as NMR DLR. Then his service was brought over to the work charge establishment and he continued for a substantial period. His service was not regularized. He approached the Honorable Court and the Honorable Court, Honorable Single Judge, the Read Court directed that since you have already regularized in respect of 8 others of the work charge,
Why he should be spared?
Why you will be spared?
Correct.
So now, more or less, it comes within the purview of that judgment which your Lordship have
Correct.
already rendered.
Correct.
That judgment which your Lordship have rendered, that recognizes the action of the state government in regularizing the service after completion of 6 years of period. I am not on that one. So far as this case is concerned, here they have, I persuaded them, I showed them the judgment. They have agreed to regularize the service of the petitioner.
Oh.
So, but what they are saying that work charge instruction, basing on which the work charge are regularized and the corresponding circulars of the government, it says a person on completion of 10 years, it was earlier 10 years, now it is 5 years. On completion of 5 years shall be eligible for regularization. They have agreed to regularize the service of the petitioner with effect from 2018. That is what is my instruction. Respectfully. But so far as, and just a minute, and so far as those 8 employees are concerned, those who have been regularized, they have been regularized from the date of their entry into the work charge establishment. That is a sheer mistake which we have committed.
Have you rectified it?
No, we have stated, we have stated in our writ appeal also that that is the mistake we have committed.
Have you rectified?
Now,
that's the one thing.
Yes.
If it is a mistake, I know the mistake cannot confer any inviolable right.
Yes.
There's no difficulty. But you have to rectify the mistake. If you have done it, rectify it. If you have not rectified it, that means this is not a mistake perceived by you. The law is clear on that.
Yes.
If you have not taken any steps to rectify it, then it's very difficult.
And the difficulty they have expressed in case of the petitioner, that once the petitioner is given the same benefit from that date,
You
there
are
are
given to
100 others
it.
who are also
Sir, you are given to
So
it.
they have agreed as per their own rules and regulations of the government.
You have done for 8. You have invited the petitioner to become 9. It is you who have created a problem.
But a petitioner service as of now has not been regularized.
Oh,
So he stands in a
understand, sir.
different footing
So
than
he
that.
says that if I am entitled to a regularization, you have illegally and wrongfully denied the right of regularization. Then in that event, one has to say regularize. Now question is retrospective effect to be given from which date? Or it will be a prospective in nature.
Yes.
So
But
the
so far as
difficulty is if you have given a retrospective date, sir, your stand will not do. Your stand must be tested
Yes.
on the score of reasonability.
But negative equality is also there.
It's not a
And
negative
against the
equality.
provisions of the statute is also there.
If the statute says regularization was a right, then you can't deny.
No, regularization is a right, but the statute says on completion of 5 years.
Correct. So according to you, there are 2 ways.
Yes.
Either you can say that the moment the 5-year period is over, from that date I will give,
That is as per the rules.
or if that is the situation, then in that event, everybody has to be given in this way.
Yes. And even most of them have been given in this way, but in respect of these 8, persons against.
So you rectify it that it is
Seriously.
contrary to,
Yes,
and show us that you have taken a step by giving a notice that it has been wrongly given. You can't avail of this. Pay back. They have been paid some amount.
yes.
Pay back. Recover.
Since when?
Shyambabu Verma will not come into your way. Don't worry. Nor Abdul Qadir judgment will come. They are still in service. You have to do this. Or if they agreed, no difficulty.
Take instruction regarding that. I am also supplying them a copy of this instruction.
So we take.
Although it is a privileged document, still.
I've just given 2 sheets of fact sheet, kindly see. 2 pages of fact sheet. Just that to clarify the whole question. It's not respectfully I say that those 8 persons are speaking this language through this script. All these submissions, those 8 persons who want to stand distinguished, but they are speaking. Kindly see one.
No, we are
That-
not
one
saying
second,
they are
Mr. Das.
distinguished.
1 second,
We
Mr.
are not
Das.
saying that.
1 second, Mr. Das. Kindly see this fact sheet, man. Those 9 counterparts, they were engaged on 12/4/93 and I was engaged on NMR 28/10/94. Then kindly see serial number 2. 9 counterparts were also NMR DLR graduate engineer were appointed as contractual assistant engineer against the regular sanction post on 27/2/2004.
You are also.
No, I am also. Next, kindly see the next page, serial number 3. 9 similarly situated persons were brought over war charge establishment on 8/2/2013 as the same statute, the same status as assistant engineer notification dated 8/2/2013. They did not do me. I had to approve the tribunal. Then the tribunal passed a judgment in my favor. Then they did the same thing. They treated me war charge from the retrospective date 8/2/2013. But that has been done. Kindly see page 75 of the return.
Then
That is there. Then, with regard to scale of pay, they granted scale of pay to those persons from a particular date, 21/3/2013. They did not give me. Again, I had to approach this on court, and the same benefit they also granted at par with them. Now, 2 stages. This war charge and scale of pay, they have treated me similar at par with them
yes.
by virtue of the honorable one tribunal's order, one other is by virtue of this honorable court's order.
Yes.
Now, third is they regularize these 8 persons. One is retired. 8 persons with effect from 8/2/2013.
But they have not.
But they have not done me. I had to approach this honorable court. Now, direction is you can't discriminate. That's all.
Another block. Subsequently, the 8 counterparts upon such regularization have already
They have been
taken
promoted.
promotion on to 8/2020.
The promotion is not an issue here, my.
In fact, those 8 persons want to see me junior. That's all. Those 8 persons, they want to see me junior. And
You say
their
it was
language is in
mistake.
scope.
How will you not rectify?
No, sir. You can't stand differently. You have to be very uniform. That's the order of the day. What can be done?
Uniformity, my lord, I can only say uniformity.
I tell you very frankly, I know the regularization is not a vested right, not a legally enforceable right. It becomes a legally enforceable right when the government consciously makes a law in this regard. I found here a law is made.
My lord, even in.
Normally, in other part of the country, no law is made.
My lord, even in case of state of Bihar versus Uday Pratap, your lordship, that is a Supreme Court judgment. There the Honorable Apex Court said any appointment against the war charge establishment is not
Sir,
a
there was
substantive appointment.
no.
And
I am
that-
telling you,
and that cannot be taken into consideration.
I
for the purpose of regularization of pensioners.
I have also held in one of the judgment work charge employees.
Yes.
I have. Because there was no scheme, there was no statutory document, there was no statutory rules applicable. Absolutely silent. That's why I say, except here, none of other part of the country, they have not made any provision. Never. Once you made a provisions and it takes a shape of a law, then you'll have to abide by the law. You can't avoid it.
That is what they are saying. They want to abide by the law, but this case of
But
those
how
8
can
others,
you nine
obviously
work,
that is a-
same department, same persons, 9 have been given, and you are sparing him? How can it be, brother?
And-
I have already delivered, so you take a
and
charge
that
of it.
first paragraph of the list of dates, which my learned senior also provided. So Lordship will look at the first one, serial 1. The 9 counterparts, they were appointed before 12/4/1993. That he has specifically stated. This 12/4/1993 has a relevance. And so far as the present respondent is concerned, he was appointed on 28/10/1994. This
Just-
12/4/1993
Uh.
is an instruction issued by the finance department
Oh.
to all the concerned department not to give, because that is a ban imposed for not giving appointment. Despite the ban, the petitioners were appointed as NMR DLR only under non-muster role. So that is the thin line distinction between that 9 and the petitioner. So far as on fact is concerned, but both of them have been brought to the work establishment. Their services has been regularized.
A person who committed a wrong is now reaping the benefit of his wrong. Can he? If there was a complete embargo, then why you have taken the?
They
That
have,
estoppel by conduct and the estoppel by your representation goes against you.
Now when you go accept your mistake. can you-
we have accepted
can you-
our mistake.
can you-
So I
That is
cannot-
what
there
is-
the appeal also.
After giving them promotion. can you
Give it
again
to-
now
give it to
bring
brother.
them down, thereafter, again you will send them back.
Now I have already delivered a judgment, so this time my brother should write.
So great.
My expression, my proposition of law is already there. I have already heard.
Yes, that I cannot.
Yes.
Great.
Call the next.
Still
Item-
continue insisting them to.
But I have done the effort. But
No,
last occasion I.
Item 34.
Oh, my lord. There has been a delay of 113 days.
Amar,
113 days.
what do you say?
The government had sufficient cause. It is up to your lordship to decide so far as the delay is concerned.
Which application is a delay?
I have filed.
IA?
Like B.
Application for delay is not served on you. Oh,
I-
sir, why are you not serving?
In course of the day.
Please,
Your lordship. Said, he will not serve.
please look at the copy of the application. For which is the application?
I number 1652, man.
So you serve all the applications and including the writ.
Read appeal.
Read appeal.
Writ appeal.
Yes, I in course of the day.
What's your good name, sir?
Jitendra Kumar Lenka.
Doctor
Jiten. Doctor.
Doctorate.
Yes, so Dr. Jiten Kumar Lenka appears and submits that he has lodged a caveat on behalf of the respondent, yet the copy of the applications as well as the writ application, as well as the writ appeal have not been served upon him. Stop. Mr. Das, the London Additional Government Advocate, is directed to serve the copy of the applications filed in connection with the writ appeal, together with the copy of the writ appeal upon Dr. Lenka
By tomorrow. By tomorrow.
by tomorrow. List the matter on the next Thursday.
Another,
Same regulation matter, juniors have been regularized.
another I is there for dispensing with filing of such kind of copy. I undertake.
All, yeah, no difficulty, we'll allow it. Good.
Item number 35.
Item 35.
Oh my God.
Item 35, I pray, but I may be excused for the day, but I have already prepared a note of submission, but somehow because of my difficulty, I could not carry it today to the court. So only I pray may be taken up on Monday so that I can,
What is this matter?
and that the honorable single judge allowed the read petition.
Oh, this is what, sir, we wanted both of you to come.
Yes.
This matter was, I took it because I wanted this to go extensively.
Yes.
Sir, what I find is I have tagged two pages. No, not this one. I have tagged right hand side. Please. Supreme Court decision, I have gone through it.
Yes.
It never talks about these things. What I gather from here that you say this house, Jhumkal, what is that house? Jhupudi house.
There are shops also.
Sir, you have stated in your petition that it is your father who was the employee of the L&T. He came after getting a settlement of the land from the then Jamindar, and then he constructed a house. Then in latter point of time, he constructed 3 rooms, 7 rooms, 3 shop rooms, 5 shop rooms, everything you have stated. And you say that continuously your father remained in the land until one fine morning they came and demolished the entire structure for construction of a flyover or a bridge, whatever, and also the railway market. There is a market complex also that has been done.
Yes.
You say that first thing is that they cannot do it. No, if they have done it for the public purpose, then the compensation has to be paid.
Yes.
In the writ petition, you prayed 2 reliefs. One was setting aside the order of the subdivisional officer, entertaining, holding that the revisional application at the behest of a tehsildar is maintainable, and then you say that you should be paid a compensation.
Yes.
Where is that act? Now, it appears that several litigations that really came, several times you came here, it went to the authorities, and ultimately the appellate authority, he found that you are entitled to a settlement of land under this Odisha Prevention of Land Encroachment Act.
8A.
I've seen 8A. Exception is that these type of lands cannot be settled, except that the other lands, if it is found that you are in possession for more than 30 years, then it is referable. The appellate authority found your position and say that it is a fit case for reference for settlement. And then told the tehsildar to do a certain act. The tehsildar instead, though he went there and found and did a lot of things, but later on he decided to challenge that particular order by filing a revisional application before the subdivisional officer.
Before the appellate authority is the subdivisional officer,
Oh.
the collector.
Before the collector.
Yes.
You took a plea that how the tehsildar can come because his order was challenged before the subdivisional officer as an appellate authority. And then he is the person who is the petitioner in the revisional application. With one stroke of pen, the collector says is maintainable. You challenge the order. The order is set aside by the single bench. They did not challenge that order of the single bench in the appeal.
Yes.
Correct? They accepted it. The fallout of the entire episode is that the order of the revisional authority goes.
Yeah.
As revisional application is not maintainable, it receives its natural death. Correct?
Yeah.
The fallout of this is the order of the subdivisional officer revives. Now, the question of compensation will only arise if the land is settled, because right to property under Article 300 capital A is there must be a right in the property. This right has not been fructified because the decision for settlement of the land has not been taken as yet. Once the land is settled in terms of this provision, section 8A, then your right to claim compensation will arise.
Yes.
So it appears that the right to claim compensation is premature at this stage, which I perceived. I was just talking to the brother during the races that I went through this. So what is required is that as per the appellate court's order, the competent authority has to first go for a settlement of the land because the nature of the land does not come under the exception. I find there are many, only one I can correlate, the gochar land can never be settled. Certain exceptions are there. It is not a gochar.
Gochar is under the OGLS.
No, here also I find it, OGL, whatever.
This one is OPM.
Oh, please, section. No, I was looking at this.
Odisha Prevention of.
Oh, there also. No, just then I make a confusion. No, it is here, sir. That is what I say. Section 7.
Yes, section 7. madam.
Please, section 7 says that eviction can be initiated, then says that settlement says provided that no such settlement shall be made if the land belongs to any of the following categories, namely the lands recorded as gochar.
That is section 7, man.
Sir, I am talking about section 7, sir. I do not know Rakshit. What is this land? I do not know what is this. What does it mean? Sarvasadharan in any record of right. I do not know what is the meaning of this. Then the lands which are set apart for the common use of the village and all these things, it is not coming. You are claiming a right in respect of the other categories of the land which does not come under this. So capable of being settled. So this has to be settled as per the order of the appellate authority.
Yes.
So let first the settlement proceeding to come. And thereafter, there are judgments you have referred. You have referred a judgment.
Human rights is individual.
Sir, I have seen that. When you talk. One of the Supreme Court judgments. Which
So many cases.
you have referred. Went against my order from home. There, what I have heard, a similar situation. There is a requisition, temporary requisition provisions of 1948 there. West Bengal requisition of land, temporary act of 1948. It is not an acquisition. So the land was requisitioned. Later on, that act was not extended. A amendment was brought in the Land Acquisition Act by way of section 9A and 9B that the property which is requisitioned and utilized by the government and having not acquired, they are given a right to give a notice and then acquire. Government did not do anything, did not acquire. Remain a requisition. Since the Requisition Act lapsed, it was not extended. The application was made for return of the land, requisition. It appears that there was already a flyover and there was already
A market complex.
No, sir. In that case, I am saying which you are referring here.
Yes.
Supreme Court judgment you have referred.
Yes, yes.
That there the main highway was constructed. And it was impossible to return it back.
Yes.
It was utilized. Then I said that since it cannot be returned,
Yes.
it is being utilized, then in that event it will be a farcical approach to return. Though he is entitled under the law to get his property returned.
Yes.
Impossibility So in that event, I just told them to go find out the compensations, and the compensation has to be determined in a prospective manner as on the date.
Yes.
Of the order, and thereafter consider. The Supreme Court in that judgment appreciated it, that in such a situations where this Act 1 is gone and everything has gone, because by that time Act 1 was also gone. Now 2013 Act came. Then in that event it says that that is the only way one can have, and the compensation has to be determined. You are referring that judgment, but I am telling you the facts of that judgment. It was in the light of that it was done. It was not done in this way. Here you have to get the land settled first, and then we will say the compensation. That's the problem which I face.
And my lord, another thing, my lord, that so far as 8A is concerned, if your lordship will find, once there is a reference, then again it has to go through a process of inquiry. That is also there. It is not automatic that
Sir,
you make an
already
application.
used and utilized. I have seen
Yes, that we have done.
The Tehsildar has come. He was there, you demolished the entire structure, and then when he went, he said, no, there is nothing. He is not found in possession. He is definitely not in possession because you have ransacked everything.
But
You have demolished his house, you have demolished his the shop loops. Where you will find, you have constructed already a flyover. You will find his position under beneath the flyover.
Tahsildar reported that he was in possession till eviction.
Absolutely, I have seen, and there was no proceeding for eviction initiated against him.
Yes, possible.
I have seen that.
and the judgment,
But the difficulty is, I tell you, that is what it struck me. If you can argue on this, because I feel that the compensation cannot be granted in the appeal now, unless the land is settled in your field.
How there is settled? There is no land.
Oh, this has to be done on a paper. And then they will say that I have utilized. Compensation under the LA Act or under the Act, how it comes?
After settlement, yes.
After the acquisition proceeding. That's why I gave you cited that judgment. I told you that there also the same situation arose. Act 1, they cannot proceed. Under the Requisition Act, they cannot return the land already utilized. 2013 Act says the mutual consideration. What to do there?
So that should be settled first.
This is what it is. We want to pass the order.
Yes, my dear.
Settle.
I have
And
not
fulfill all the conditions.
And
The appellate court has found.
Past in
The
that
appellate court has found.
This
This order is staring at your face.
appellate court has finally said that it is a case for referral.
True, this is a case means he has found the position, he has found everything on
Yes.
that. It is a case of a reference, then immediately you have to just decide and.
Yes, 8A has to be decided, man. 8A reference.
And we will record that you will not insist that he is now at present not in possession. We'll record everything.
But possession, because the statute says it, the inquiry has to be done.
Appellate forum found that he is in possession and thereafter referred because he becomes entitled to have the settlement of the land, and thereafter we will record all the finding of the appellate forum.
But the
Subdivisional officer's finding will record.
but subdivisional officer has not given
He
any
has
finding.
no right to settle. Can he settle? He can make a reference. But
Reference,
while making a reference, he has found that's a fit case because he fulfills all the conditions of those law.
well,
Now I got your game is well known to me.
no, my lord, I'm not saying that.
Tehsildar did is well known.
My lord, pursuant to the order of the subdivisional authority, appellate authority, the Tahsildar has to make a reference under
Sir, what
8A.
he did is well known. And his conduct is that when he found that he has nothing to do, because all the documents are in their favor, Immediately he approached the revisional court, revisional authority, filed the revisional application. Just imagine. An adjudicatory authority is a party to the litigations and going and challenging the order. Because his order is upset by the appellate authority.
Here the land is already recorded in the name of government. So that is why the council.
Sir, then the law also says that where the land belongs to the government and somebody is found in possession for a pretty long period of time, and if the nature of the land is not such which comes under the exception, then he has a right to get a settlement.
But right to get settlement subject to 8A. Your Lordship may kindly see 8A for a moment, man. For a moment. 8A. 8A. 8A, your Lordship may kindly see. 8A, where in course of any proceeding instituted under 4, 6, 7 and 8. 7 is the eviction proceeding.
Sir, let me, because I have burned my midnight oil, come to first section 4. Section 4. Now I'm taking you to, I'm taking your brief to argue on your before it. Yes. Come to section 2 first. Hey, give him a copy if you want.
Section 2, man.
It says the subject to the provision of the debt in court, the following class of land are hereby declared to be the property of the government for the purpose of this act. Namely, all public roads, streets, lanes and parks, bridges, ditches, dikes and fences, all are beside the sea, the bed of the sea and a harbor, everything has been done. Then any ruler of the Indian state must be the state of Orissa, Jamindar, proprietor, sub-proprietor, or any other tenure holder. That means he claims that he has got from Jamindar, so this becomes a government debt. There's no difficulty. It becomes a property of the government. Now we did not have to delve more. Then come to section 4. It says that any person unauthorizedly occupying any land which is a property of the government, that is under section 2, property of the government, shall be liable to pay by way of assessment what if the land so occupied was at any time assessed to rent, the full assessment for whole of the period in occupation, or a part thereof proportionate to the area occupied as the case may be, provided for a special reason the Tehsildar may impose full assessment of rent or on. Second, if the land so occupied was not at any time assessed to rent, assessment of an area occupied calculated for the same period at the rate imposed on the land of a similar description and with similar advantages, so you will assess the rent what for his occupation. Then provided where the person unauthorizedly occupying such land is a landless person, the amount payable by him by way of an assessment shall in no case exceed an amount equal to 5 times the annual income. So it is not that you cannot, you have to assess the rent and claim. Then come to section 7. Any person unauthorizedly occupying land for which he is liable to pay an assessment under section 4 shall be summarily evicted by a Tehsildar, and any crop or other produce, any encroachment as a building or successor shall be liable to forfeiture. Provide that in case of a said encroachment, the Tehsildar shall give notice to remove the same. Then 2, notwithstanding anything contained in subsection 1, that's a non-obstacle law, where any land is in unauthorized occupation of an person. The Tehsildar may, instead of evicting such person from the land in his authorized occupation, settle the same with him. So, however, the land so settled with him together with the land excluding the homestay, if any owned by him and the lands owned by all other members of the family who are living with him in a common lands, shall on no account exceed 1/6 standard acre, and shall not include more than 1/10 of an acre of a land which is being utilized or can be utilized for the purpose of the homestay. That where any land is in unauthorized occupation of a homestay-less person who is being utilized by him as a homestay, the tehsildar shall, instead of evicting such persons, settle the same with him, so however, that the land so settled with him shall not exceed 1/10 of an acre. So, what does it mean? That instead of evicting, if he is found that he satisfies these conditions, then it is a fit case for settlement.
Yes.
Then comes the proviso, provided that no such settlement shall be made if the land belongs to any of the following categories. Namely, first is recorded as a gochar. So the gochar land, if unauthorizedly occupied by any person, no settlement can be made. But in respect of others, it can be. And then come to 8A. Please come to 8A.
8A. Yes.
What it says. Where in course of any proceeding instituted under section 4, 6, 7, and 8. Correct? It comes under 7.
Yes. Your Lordship may kindly see.
Against any person unauthorizedly occupying any land, it is proved by such person that he has been in actual, continuous, and uninterrupted occupation of a land for more than 30 years. By the date of the institution of the proceeding, the tehsildars and refers the case to subdivision office.
Yes. Now, my lord.
Now, please, on the receipt of a reference and the subsequent one, the subdivisional officer shall give the department of the state government to which the land belongs an opportunity to show cause against the settlement of a land and may make such inquiry, further inquiry as it did 3. If after taking such inquiry, the subdivisional is satisfied
Yes.
that such a person has been in occupation of a land as aforesaid, he may by order settle the land with him.
Yes.
And every such settlement shall be subject to such conditions regarding assessment and payment of rent as we have described. So,
Yes.
what he found that he was satisfied that is a fit case for settlement. Look at the order of.
Well, that order.
Please.
Yes, sir. That order is not a process under 8A.
Please.
You may kindly see.
Order.
That is at page 74 of the writ petition. Page 74.
When you visualize the situations, he has referred a very interesting observations made in the encroachment appeal case, which has not been challenged by you. Dismissed or decided in 1993.
I have proved twice, man.
Page 82. Please come. The quoted portion of the 1993 order.
Yes.
It is the provision of law in OPLE Act that if the encroacher proves his undisputed position for more than 30 years, the case should be referred to this court. It is also the doctrine of rule of law that if the encroacher on receipt of a notice pleads that he is not liable or being proceeded under the Act, the tehsildar shall make a summary. The provision of law also indicates that the tehsildar shall make a summary inquiry. The provision of law also indicates that the tehsildar is required to refer the case under section 8E of the act. But in the instant case, the Tehsildar neither referred the case to this court as provided under section 8A, nor made an inquiry to determine the liability of the encroacher as provided under section 7 of the rules. The Tehsildar again erred in giving his finding only basing upon the raw record evidence without making a spot visit, which is totally in contravention to their procedures. Then, in this appeal, this court has approved for settlement of the land in favor of the encroacher for fixation of rent as provided under the OPL Act. If this is the positive finding, what remain, I do not.
Lordship, may kindly see page 80. Page 80, my lord.
He is relying on 93 proceeding, eviction proceeding initiated against him.
After referring, finally what he says, your lordship may kindly see.
Ultimately, I do not want to go into this. This finding is staring at the face of.
But that finding is there, my lord. Only one
Only
way.
thing is, will you go for a reference or not?
Yes, the reference.
We will record everything.
Yes.
That what is required. Brother, that's to be.
But just your lordship is closing that. Your lordship may allow me just 1 minute, man. Your lordship may allow me just one. Your lordship, he was closing. I'll not, but page. The lordship is closing this matter. So what I'm.
I heard something else.
No. Just allow me one. That is what I'm saying. Page 82. Page 82. This is the part of that order, man. As the order of the Honorable High Court, the writ petitioner supplied the required documents to the Tahsildar Rourkela as per the provisions of section 8 of the OPLE Act. But the Tahsildar on dated 25/1/2006 passed an order stating that as there is a status quo in WPC number so and so, no further step can be taken till disposal. After some time of the above order, the Tahsildar on so and so date demolished the house, shops, and other structures of the appellant. Being aggrieved, the appellant again filed WPC so and so in the Honorable High Court. Due to non-appearance of the opposite party, the appellant filed one contempt petition. Then next, the Tahsildar Rourkela fixed up the date for hearing of the encroachment case and passed order on 18/3/2009 dismissing the encroachment case, which complete violation of the appellate court's order dated 10/9/93, order dated 10/7/1994 of the Honorable High Court, as well as his own orders 93. Also peruse the order dated.
This is what I read for you, sir.
Yes. Your lordship have read that.
Please.
Also peruse the order dated 10/9/93 passed in the encroachment appeal case. So
this is very important.
Yes, then he refers to that order.
No, read that order.
Yes.
I read it so clearly and loudly for you.
Yes. In the provision of law in OPLE Act that
you need not have to come to the next page.
Next page, man.
First paragraph.
In view of the above discussion.
No, in this appeal. Don't
in
escape.
This appeal.
Because the earlier paragraph is very important. Yes.
I was trying to read the entire paragraph. Your lordship,
in
this appeal,
yes,
has been approved for settlement of the land in favor of the encroacher appellant for fixation of rent as provided under the OPLE Act.
So it is a clear-cut finding.
In view
then in view, he passed something which is beyond the 8A.
In view of the above, I am of the opinion that this proceeding is absolutely a referable proceeding.
He could not have. He could not have. After this finding,
yes,
he could not have. After all, he did it.
No, my lord, he has put, if your lordship will look at that the previous page your lordship says.
So that is what I say. Once he has said it's a referable case, then let it be decided. But we will make all these observations which born from the record.
Yes, my lord, that 93 order, which has been quoted here by the appellate authority, that 93 order is also says that it is a referable. That is what I am trying to say. That 93 order also says the case is referable.
When a positive finding is made, visualize his impact.
Positive finding is something
That is be enough. Let him decide. Can he take a decision?
It's a competent option.
I understand, sir.
So if a reference now pursuant to the order of the appellate authority as well as the single judge,
I will dictate it.
if a reference is made by the Tahsildar, then it has to pass through the test of
We
evidence.
are not interfering, but we are making it very clear that this after the settlement of the match, the finding is that in 2008 the entire order was the structure was demolished by the Tahsildar. All these things we will retrieve, and then we'll say within a time frame we'll have. Keep it in the range. Come during the weekend and
The appeal was only preferred for the purpose of compensation.
we are not entertaining. We said that only for the purpose of compensation, which we are holding that it is premature at this stage. And why we are holding premature?
Because not
We will record.
was certified.
Yes.
Item 36.
Details.
Delay.
You already said mentioned.
Yes. What you say, sir?
The grounds they have taken in IA for permanence of delay, either official delays from the date of the judgment, which days have been passed, but they could not file. There was official delays. If it is satisfactory, then it may be considered.
The 88 days delay, they actually pursued the review remedy that was also there, which was dismissed, and they immediately came up before this court, challenging the parent order. That's a.
No, I am not opposed. Because things have to be settled very.
Application for confirmation of delay of 88
But you have to show when you have applied for the certificate copy. That's all. You have only filed download copy.
Yes.
You show us the application for certificate copies, please. Until now, we are doing that.
In fact, it was filed in the review, like I am filed.
Not dispensed with that. You have to show that you have applied and then be dispensed with on an undertaking to file it. At that time.
I have got it and I have filed it for the letter.
I understand that you have to apply afresh, otherwise you can't.
I shall.
Application within 20.
Item
It's, when? Next week, actually, 10 week. 23rd. 23rd.
yes, sir.
Right.
Item 37.
23rd.
37.
You for the calculation 9 days only. But the certified copy I got late. 21, 24 was the judgment. 25 was the judgment. I have filed it on 29/4. 21/3/25 is the date of judgment. 29/4/25 I have filed it.
I means apply.
No, I have filed it. The appeal I have filed it. I got the certified copy. That is. If you calculate from the date of the receipt certificate, there is no delay, but there is a delay of 9 days. Well, that is admission next week. Any dates? 22nd. Right.
Item note 38.
My lord, I am on BC, my lord.
Yes.
My lord, I have filed an IA number 2441/25 seeking grant of leave to file the writ appeal. In the impugned writ,
Your third party.
my lord,
Are you a third party to a writ petition?
I am not party to the writ petition, my
When you
lord.
file your opposition,
My
leave to appeal is filed.
my lord.
Copy has been served on you?
Yes.
My lord, the notice has not been issued, the press.
So,
The respondent number 1, filed
38.
there is only one respondent.
notice has not been issued. my lord.
So there is only one respondent, so I'm confused.
This matter relating to management of the service cooperative society, my lord. I was continuous,
Seven respondents.
my lord.
But why it is not shown in the system?
System.
The first thing. That's
On the list.
You are representing two. Can you represent three?
You may allow.
2 to 6 my lord state is representing.
3, 4, 5.
Can you
6
represent-
also. Yes, 6.
Up to 5.
6, 7 I have to take notice, my lord.
Huh?
Yes, madam.
1, 6, 7 I have to take notice, my lord.
No, you have to take notice for one also.
1, 6 and 7.
Notice.
Yes.
3 weeks. Weeks.
Item 39.
Yes.
That yesterday that your lordship that I had matter regarding the blacklisting. My the
Oh, 39.
that is your lordship that regarding fair opportunity of hearing, double jeopardy, your lordship on that regarding the going condition. First
Yes.
up to violation of must have been 2. And they are recently 2000
On that, my lord. I'll explain.
with that part in your lordship.
He wanted a time.
No, Miller, your lordship.
You have already submitted the judgment.
Yes,
Then he wanted a time.
yes. That whether it is be a violation of 2 condition or single or and your lordship.
It's that interpretation of that and I'm relying on that. The constitution made that where the provisions of the Terrorist and Disruptive Activities Prevention Act 1987 has been interpreted. Is 1994 5 SCC 410. May I take your lordship to para 40? 40. I'll just place it, my lord, and then I'll explain. Schedule 1 to the arms rule specifies the categories of both arms and ammunitions mentioned therein. This is what has led to use of the words arms and ammunitions in section 5 while referring to them as those specified in column 2 and 3 of the category 1 and category 3A of the schedule 1. The word "and" has been used because schedule 1 specifies both arms and ammunitions in column 2 and 3 thereof. The word arms and ammunitions in section 5 means any of the arms and ammunition so specified, or in other words, any arm or any ammunition specified in column 2 and 3 of the category 1 or category 3A of the schedule. The word "and" instead of "or" is used in the expression any arms and ammunition specified because reference to both is made as specified in the schedule. For this reason, the word arms and ammunitions are not to be read conjunctively. This is further evident from the fact that disjunctive "or" is used while describing other forbidden substances like bombs, etc. Yes. Yes.
The reason was that the purpose of this act to be prosecuted, it is to live in
Yes.
we see that in a tada, any arms and ammunitions, so one will carry the forbidden arms,
Yes.
will not carry the ammunition,
Yes.
but he will be absorbed of this.
Yes.
That what the spirit says that it should not be, because the purpose and object is that the forbidden things cannot be done.
Yes.
Whether in a criminal case, which is where the offense is against the public,
Yes.
those interpretative tools we also borrow in the civil law
But civil,
or a contractual field.
but a contractual field, why it will be borrowed? That is what the reason I am saying. The Lordship may kindly see the judgment of that Wanda infrastructure, which I in fact relied on yesterday for the purpose of that SOCOs and other things. But a very relevant infra. Yesterday I relied on this judgment, and that was in respect of the SOCOs. So far as SOCOs, I have referred to this judgment. Now, on so far as this interpretation is concerned, Your Lordship may kindly have a glance to para 24. May I place it, my lord? As per the law laid down by this court in catena of decisions, debarment, that is blacklisting, is recognized and often used as an effective method for disciplining deviant suppliers, oblique stroke contractors who may have committed acts of omission and commission. It is for the state or the appropriate authority to pass an order of blacklisting stroke debarment in the facts and circumstances of the case. Therefore, the High Court has erred. I am not going to that. I am only saying, my lord, this first line, as per the law laid down by this court in catena of decisions, debarment is recognized and often used as an effective method for disciplining deviant suppliers and contractors. Now, your lordship may kindly come to that provision under the OPWD code. That chapter, volume 2, chapter 6. The chief engineer of the department, my lords have got this book, 475 page 475. That codal provision for blacklisting. 47. The chief engineer of a department may blacklist a contractor with the approval of the concerned administrative department on the following grounds. C. I'll straight away go to C. Constant non-achievement of milestones on insufficient and imaginary grounds, and non-adherence to the quality specifications despite being pointed out. Now, here there are two situations, my lord. One situation preceded by and succeeded by and. The first situation is if somebody doesn't timely execute the work. That is one situation. The other situation is if he doesn't adhere to the quality. Now, both these situations will not fall in all circumstances. These situations, there may be situations where the work has been completed within the time frame, but the material used is very bad and for which the bridge collapsed. Then in that event, he will take a plea that no, merely because I have delayed. My lord, I'm just placing my lord. So this and has to be read as or, because there may be situation despite repeated notice, despite repeated persuasion, somebody doesn't complete the work. But can he go scot-free by saying that no, you cannot take action against me because the other condition I have done the quality work, but I could not complete the work within time.
That is why one has to underscore.
Yes.
Both these equations. You have already taken out a particular clause that if you do not complete the work timely, then you
Yes.
You can impose penalty on that. Please consider two aspects. One is to perform the contract within a time.
Yes.
And the conduct is such that it regards me from any future contract.
Yes.
Once the second concept invites a civil debt or a commercial debt, then one has to interpret the law in such manner. Every breach of the conditions does not mean that there will be a blacklisting that is covered. That is what is saying that untimely work is not only the ground, but if he has not supplied the material with the specification of his skill, that means there was some dubious things that has happened. You can debar it. That is why one has to understand the Samyada's judgment, which you are referring in that, because the Supreme Court very clearly, that is, there cannot be any quarrel on that. That a person can be charged under the TADA if he carries any arms and ammunition. If this is to be read as conjunctive, then a person who will only carry the arms, which is forbidden, but not the ammunition level. He will go beyond the scope of the Tata, which is absolutely wrong. Or a person who will only carry the ammunition, not the arms, then he will also go beyond the purview of Tata. The court says that this is absolutely, it will frustrate the main purpose. Here is the purpose of the blacklisting, that's why it's an extreme thing one can take as a. And therefore, the validity has to be considered. And in a criminal case, the interpretative tool is different. Because it is an offense or a crime against the society. And it is in a contractual field.
My lord, even if it is even if it is in the contractual field, my lord, if your lordship would read that provision makes two specification, and two specification under all circumstances cannot happen simultaneously.
It has.
But my lord,
That is why the penalty was imposed. You have already done imposed the penalty.
Yes.
Is liable to pay or he has paid, I do not know.
Recovered from the bill.
It is recovered, if you have already recovered. Because you do not suffer any loss in that sense. Once you recover the penalty base, the left out work. You have you got it done with somebody else. Now, what is that?
but for penalty he has filed a separate writ, my lord.
The price, the total amount which he has to do the work within that is increased. If you have suffered a lot for that, you have already recovered by the.
But penalty he has challenged in a separate set of writ application. Those writ applications are pending, my lord.
Yes, the validity of the.
Work. Both can coexist. Just one that both cannot coexist. We see both function. The non-achievement and the quality specification.
Yes.
Both are lacking, then blacklisting, because it is harsher and it's livelihood. You are touching the livelihood of the person.
So, my lord,
For 6 years. You are defining 6 years. You are not.
but my lord, if your lordship will look at the fact and circumstances of the present case, he was supposed to complete the contract by 2019. However, he was persuaded with all facilities up to 2023.
The drawing was.
He
provided
never
2021.
completed that.
The drawing was provided.
I would say the harmonization.
And regarding
And
delay,
as far as-
the delay, Miller, the drawing was provided 2021, Miller. This contract is 2018
And both-
and drawing was provided 2021 for which, Miller, because of the, is it Malkanagiri district, Miller, is Miller coming on the Naxalite zone, the complete deviation has changed, Miller. That situation I'm not there doing fast bridge. And is the Naxalite zone, Miller, the completely drawing was designed and changed, Miller. So this, Miller, this exact. Miller, oh,
You have to consider.
yes, lords. And
Yes. Under what circumstances?
exact, Miller. And your lordship, Miller, your lordship
And so far as that SOCO's notice is concerned, SOCO's notice given to the petitioner explained everything. But instead, the petitioner only replied that the case is pending. So I cannot give any SOCO's reply right now. That is the only reply, which was found to be not satisfactory. That is his second limb of submission, my lord. Once nothing has been spelled out in the SOCO's reply, so what the authorities have said? The authorities have only said that your SOCO's is found to be not satisfactory, and preceded and preceded.
Your reply is not.
Yes, I'm sorry, your reply. The reply is not found to be satisfactory because it doesn't contain anything about the SOCO's. The basis of allegation of the SOCO's has not been explained, replied. Nothing has been taken care in that SOCO's reply.
The SOCO's report mean interfere of the super state on a limited point. But the point is that the super is particularly a statutory process. When the super can be issued, the grounds are given. Yes. If it appears to the court that the grounds are not satisfied, or to really bear no consequences. Okay. Talking about the reply set we are more on the validity of the summons. You have spent the ground on this the supervision.
That is 34C.
No difficult. So cease to be interpreted.
Yes.
Conjunctive or disjunctive.
Yes.
If it is conjunctive, show cause has to go. If it is disjunctive, the show cause may sustain. We will not interfere with your speech.
And only I will just reiterate that once that disjunctive that has to be disjunctive, because in all circumstances that possibility may not happen. There may be situations where there will be a delay of work. There may be situations where the quality has been compromised, which may lead to any kind of fatalities. So, and there may be situations, and there may be situations where both can happen. So, the blacklisting cannot be referring to the findings of the Supreme Court, the observations of the Supreme Court, so far as the defiant contractor is concerned. So, Lordship will look at that to discipline the contractor, to discipline the defiant contractor. That means it both has to both is not required to exist at the same point of time. It has to be read disjunctively to address the situation. That is what my only argument and judgment I have also referred. And so far as that and or is concerned, there are two further judgment. I'll just pass it on that on and or. But this is the judgment where may not that may be under the criminal law, but it addresses the situation in that para 40. The two other judgment, if your lordship will
consideration of the representation submitted by the petitioner against such adverse.
But the lordship will go through the entire counter affidavit. The entire situation has been explained. By. And this is another judgment that the and or para 7. I need not place that because that constitution based judgment, but I feel may address the situation. Para 7.
One more judgment, the Lordship 2025 volume 2 ACC, where the same and or issue was the Honorable Supreme Court pleased to help if the clause is unambiguous and clear, then it cannot be convicted. 2025 volume 2 ACC similar. Yes, Lord. Yes, Lord. Yes, Lord. Gopal Krishna and others. The word is that like that. It is normal. I may permit to place that paragraph.
Here, my lord, the situation is different. That situation is.
Yes. And that if the language used in the statute is arguably was clear, to say that conveys the clear message, that no external aid should be taken to interpret any of the words or the expression.
This is good. Exactly right. Yes. No. Yes. Pleasure.
Just put a small note by Monday. Only to summarize my points. Your Lordship. Your Lordship. Right. Item 40.
My lords, I'm sorry, I'm on VC. May I please your lordships?
Top end. Top end. Fine. Item 40.
My lords, I'm sorry, I'm on VC because of my lord little inconvenience I had in the morning. So may I pray subject to your lordships if I would rather prefer to do it, my lord, physically if it can be on Tuesday or Wednesday, subject to your lordships. Convenience and my co-counsels.
Come on Wednesday, sir.
Deeply obliged.
Item 41.
Make it easier. Lordship, this I am appearing for the petitioner. Lordships, in this matter, this is a matter wherein I have bought the contract at the time of VAT. I have completed my contract at the time of GST. The differential amount I have paid, but I have not been reimbursed despite having a circular of the Odisha government, which is an admitted use, case of admitted use. So
Who is for the other side? Who appears? Mr. D. Sripati.
I beg pardon, my lords. I'm appearing.
who is the party?
Lift irrigation?
They won't do separate.
Separate penal.
You are appearing, Mr. Tripathi?
Yes, my lords. My senior name is there.
Yes.
We are appearing in this matter, my lords.
You serve copy
Yes, it has been served.
on
The
Mr.
name is being
Tripathi.
reflected in
The name does not appear from the order.
No, on the last order, my lords, we had not filed our wakalatnama.
Yes.
After that, my lords, we filed our wakalatnama after November 25th.
Has been served here. Your issue.
Yes, my lords, we have the copy, my lords. We will take instruction in this matter, my lords. Kindly let it come after 2 weeks, my lords. We'll bring the instruction.
The admitted use is 123.
Correct. So 10 days she want.
Sorry,
10 days accommodation to take an instruction
Yes.
she wants. So after 10 days, you just fix the matter.
28.
It's a fixed. They have the public.
They have.
They have.
We have the copy, my lords. We have the.
Sir.
My instructions. Okay.
28.
Grateful, my lords.
Obliged.
Yes.
Item 42.
State is required the counter-affidavit on the cases. Lordships have passed an order on 3rd of July, last one. Some time to file the counter and so also. And advocate general.
So time to file the counter was not extended.
Lord, it was extended on the last date.
Where?
They said paragraph 2, my lords, order dated 3rd of July, 2025.
Yes, I'm looking at the order.
Yes, my lordships have said, Lord Council has said, counter-affidavit is yet to file, matters will be taken up on 17th July.
That's where is an extension of time to file counter.
Maybe by 17 they should have filed. Possibly.
There is no reflection.
There is no, your lordship is right.
How long will you continue? I have a different principles, you know, by this time.
And I know, I understand, but at
The
last.
first extension is automatic, no problem, but from second extension, you'll have to be put on terms.
Last time, 2 weeks time, they will grant it. So
That's very, very regular feature somewhere else. Last chance, special chance, special last chance. No, sir. How long will it continue? And this is, since January 2025, the matters are regularly being taken up and yet it is not filed. I leave it to my brother, but
request to the honorable court. Last time it's 2 weeks time may be granted so that I can, because matters that various other
convince my
matters,
brother.
those who have been,
Convince my brother.
I'm requesting the bench, my lord. No doubt, for division bench.
No, that is what is there.
There was some indication. Will object to. I'm asking Mr. Patnaik and Mr. Manti.
They're all the same.
I'm not leaving it to you.
No, I'm not.
It is not for you.
And we are not option. So my friends were this side also, they know the difficulty, so that is why.
I was also.
So I can only.
I was also part of that and Mr. Parija also. 10 days? 10 days.
2 weeks. So there are batch of matters. It's well done.
I think one will suffice or what?
Some differences in facts, figures, so that is why 2 weeks time may be matter, so that.
They got 1 week for rejoinder and then you'll actually post.
2 weeks, then rejoinder.
1 week, 1.
2 weeks from. If Contractual is filed within 2 weeks, then serving
The
copy
record
of
is this one. Record, sir.
Sir.
Their conduct has to be reflected.
P720.
No, 7 orders have passed. From 2nd of January. No, from 8th of January. In the meantime, let the counter-affidavit from 8th of January it is. Just before the IA, 8th of January, you'll find the liberty was given. By counter. Then the several dates.
On 8th of January.
5.
25. On the the matter is put at John. Filing.
liberty is granted to the petitioner to file a rejoinder, comma, if now after three weeks, just any date, suggest.
11th August.
Yes, true, all of you.
Grateful. Item number 43. What is it? 6th May 2024. It has not yet complied. They are second time earlier around 1996. You have to comply. You have to comply. No. Extra copy you have to serve. Short question. Oh, it's solved. On the same day solved. On the same day solved. This is the receipt.
Now it's the contempt. This is the first motion. It's the first motion.
Second.
Then the service of copy is the first move, sir.
Means after the contempt application is filed, this is the first motion.
No, this is the second.
Second time.
First one was.
First motion has already been, is over. Was there any direction? Oh, service was directed.
Yes.
So it's literally a first motion.
Literally thought, that's what I want.
Give them, file your counter. That's the right. The application for contempt. The application for contempt had.
Taking the transport contract, my lord, wherein the petitioner has quoted the lowest rate, but he has not been allowed to work, stating that the person who has quoted 30 rupees more price, he has been allowed in the tender by the tender committee, my lord.
Yes.
The lordship may see the it is because they have not supplied any copy to the me. It has been filed in the counter-affidavit filed by the opposite part number 2 and 3, my lord. At page annexure G/3. Tender committee meeting held on 25/3/2025.
25/3/2025.
Annexure G/3.
What they have said.
Page 32 of the counter-affidavit, my lord.
Yes.
It is the high-speed opening of the by the tender committee. The lordship may see.
You have quoted.
69, my lord.
Correct.
The next page, my lord. Accordingly, after trade discussion on the workable rate, the committee decided to open 3 sealed price bids which were inspected by all tenderers and members being intact, and then opened in the presence of all members of the district tender committee and tenderers. The quoted financial specification of the price bid of the 3 bidders for transportation of PM Poson forfeited rice from OSSC depot of Bhadrak district to all schools point of 7 blocks, NGOs, SSG's point, including loading and unloading and other incidental charges, were found as follows. CP Biraj Kumar Bhuiya, 87.77.
Whatever. Then from the comparative.
Parthasarathi Raut, 98.
From the comparative
From the compared specification of the price bid, it reveals that Sri Parthasarathi Raut quoted 98 per quintal, and it is found to be the closest one to the workable rate as calculated by the committee. After thorough discussion, the price bid of the bidder Sri Parthasarathi Raut was unanimously accepted as workable and recommended for engagement for transporter foodstuff rice under PM Poson scheme for the year 2025.
How can there be?
My lord, the committee decided the workable rate is so low price, he quoted that it is not workable.
So it's good for them if he can work with such a low price. Where is the difficulty? Where is the difficulty? It is a public money which is saved. It is his headache how to work. He is not entitled to any charges beyond 69.
Correct, my lord. And ventilating grievances was made representation to the collector, that is page 43. You will not be director collector to decision accepting a lower rate as the
Bad person. I do not approve the concept of representation to be considered theory. If I find it is a right, I will decide here and now. If I find no right, I will dismiss here and now. But I will not leave it to the authority for another round of litigation.
Subject to authority permits me, my lord. And for the successful.
No, I will hear you.
Right.
So this is what has been. There is anything more? There is anything more which would come?
Madam, condition of tender, your lordship may see, that is a condition. If they will go for any workable rate, then they have to.
Where is that?
Madam, page 16. Your lordship may see my request on page 16, madam.
एक बताओ तो.
Page 16, madam. Clause 2. General instructions.
Yes.
General instructions and guidelines for the tenderer, madam.
2.4.
It is 2.4, madam.
Yes.
The district tender committee reserves the right to negotiate with the L1 tenderer for workable rate for transportation of PN postponed rice. Then 2.5 for all the tenderers. If they will fall that I do not meet the price, then they will go for all the tenderers. Negotiate with all the tenderers for workable rate, madam. In the tender, there is no workable rate has been stated, madam.
Yes. Then,
my lord, your lordship will see page 17.
Yes.
Clause 5, quoting of the rates, which is important one.
Yes.
5.1, the last line, my lord, in clause 5.1, the rates quoted should be final and the tenderers shall not be allowed to change the same under any circumstances. The lowest quoted rate of the eligible tender will be accepted after necessary approval by the committee. Then 5.2, how the rates will be quoted? 5.3, my lord. The eligible tenderer quoting the lowest rate per quintal shall be considered for negotiation and for final rate, my lord.
Yes.
My lord, thereafter, it has been stated all other things, which is I am not concerned about that. And clause 10, page 20, my lord.
And they must have taken it from 5.4.
I have seen that. I have seen that.
5.4, my lord.
No,
That is not the workable rate, my lord. That is the earlier.
Understood. Then
the person who is selected, he was working here.
Show me another thing.
My lord. And the security deposit is there, 50 lakhs.
What is that? Everybody has done it.
Yes, my lord.
So next,
anything
more?
Anything more? What they are saying that I have to show?
Yes.
That I have.
What is their stand?
Yes, ma'am. I am showing that. Well, 17, clause 17, your lordship. See page 21. That is a clause where quoting of same rates by more than one tenderer and negotiation with tenderers, ma'am.
True, is a matching.
Yes, ma'am. There they have what stated, my lord. Clause 17.1. Your lordship may see. The lowest rate quoted by tenderer cannot be treated as accepted if not workable. As per the decision of the district tender committee, the decision of the district tender committee is final and binding. My lord. Then next 17.2, your lordship may say, that is relating to the same rate.
No, it is not applicable here.
Yes, ma'am. 17.3 is important, my lord. Because the district tender committee reserves the right to negotiate with the L1 tenderer, my lord.
He will be very happy to do it at 98. He wanted to do it at 69.
Yes,
If it helps negotiation, then he is happy to do it at 98.
that is my case, madam. They have never negotiated. They have directly stated that the persons who have quoted more rate, it is adjacent to the workable rate, and workable rate has been fixed by the committee. Now they have stated in the counter affidavit, which could not be.
Yes.
And ceiling price is 150, my lord. The highest price is 150.
Yes. That's all?
Fine.
Yes, sir.
In counter phase 6, we have stated that tender committee fixed a workable rate, that is 98.99. So
Can it be? Can it be? That's a workable rate.
because last price that was
Then
put
what
is
for?
98.
Sir, just tell me, what for the tender is floated? If the workable rate is 98 and that is the barrier, then everybody who will come and quote 98. One who has quoted less, he will be very happy to work at the higher price. Why you have not given?
You let me direct to the collector because he may file a representation. Taking account is lower rate, he will dispose of the petition.
We will hold it subject to hearing Mr. Roth. Yes.
I have, to assist my lords, I have prepared a small list of dates and also a compilation. Just have this list. But I'll try to assist my lords on this. That should see. Only 2-page list of dates now. The tender notice, a committee was constituted for the purpose of evaluation of the bids. Committee members are 19 numbers. Then date of opening is there and all schedules are here. Whatever is agreed by the petitioner is, he has quoted lowest bid and there is no point in rejecting his bid because the concept of workable rate is not there in the tender. That's what he's saying.
He says that workable rate means what? He has quoted certain price.
Right, ma'am.
Now, if the tender committee has to arrive at what would be the workable rate,
Right.
then what should have been the criteria?
Right, that there is no gray area over there. But the tender bears a specific clause. But there are two things. One is the aspect of lowest price, or other is the aspect of a workable rate. Now, workable rate, the committee has the jurisdiction to decide what will be the workable rate, and also there is a basis. This is because it's a transportation of PM portion from one place to different schools of the district, different schools. Basing on the distance factor, that there is a school nearby the headquarters, there is a school at a distant location from the headquarters, there is a school in the middle part of the headquarters. But that is an expert assessment, and there is a procedure how to assess the workable rate. Now, the tender conditions specifically says, the lowest bidder has no, that's not the law decided by the state of Jharkhand. I am citing the judgments also. The lowest bidder has no vested right, rather an absolute right to be considered for being awarding of the tender. That's not absolute or vested right. Now, depending upon the decision of the committee. Now, your lordship, see, I'll just again.
So that decision of the committee is sacrosanct for all purposes, immune from any judicial interventions?
I can't say it is immune, but I'll try to satisfy my lords from the tender concern itself. But before I take your lordship to the merits involved here, I humbly contend that this petition is not maintainable at all.
Why?
Yes, look at the prayer now. Kindly look at the prayer. But that's my first point. Opposing this petition, kindly look at the prayer. Kindly see the prayer at page 10.
Yes. Yes.
But kindly see the first part of the prayer.
Yes.
Here he is asking to accept his bid, lowest bid, and award him tender. Kindly see him. Did you therefore pray that this honorable court may graciously be pleased to admit this writ application, rule SI so and so, calling out directed to finalize the tender as per tender call notice dated so and so by appointing the petitioner as transport contractor for transportation of foodstuffs so and so. So and so. He is asking to quash the entire tender process. In my respectful opinion, this is a very mutually inconsistent prayer, and then the judgment of the Honorable Supreme Court, I'm giving the compilation mirror very clear. Kindly see the first judgment of mine. You cannot make such a prayer. In one writ petition, you cannot have mutually inconsistent prayers. Kindly similar, the Union of India versus N. Murugan, that is at paragraph 26. Kindly see this.
It gives me a nostalgic feeling. And I was on that side of the room. The moment I find from the brief, it's very difficult to answer on merit. Then take a technical point first. And trash it on a technical point. Do not allow the merit to move.
Incidentally, we are following your lordship footsteps.
So, that's the quality of
incidentally, eventually,
that is why.
Eventually we are following your lordship.
The background
civil. CPC, the man who has gone through CPC.
No, you are all-rounder, I have seen.
Big pardon.
You are all-rounder, I have seen. Right from NDPS appeals and
Grateful.
No, that's the privilege council
Enjoy
enjoys.
what fell from your lordships, only to add a line. I tell he is the future. He is the next generation has arrived.
That's your turn, sir. Are you not realizing? You are so casual when you make the prayer.
What I am stating, my lord. At that time, my allegation is they have not supplied me any copy. They have neither downloaded the copy
Sir,
or uploaded it.
Can you seek for a cancellation when you got to know? Will you not amend?
My prayer, second prayer,
You do not know what is that. Entire tender has to go.
no, my lord, not the entire
You
tender.
say that the language is. May I?
Yes.
Please pardon my impertinence
Yes,
in
ma'am.
this regard. It's a hopelessly drafted petition, does not carry any meaning at all. The English language, if you read, does not carry any meaning at all.
For that reason, I
Please, why all
and
the action
why all
of
the action of
the
the opposite
opposite party? Please,
in
I'm
not
reading.
in
I'm
not
reading. This is the prayer a release claimed in a judicial proceeding.
My lord,
Why all the action of the opposite parties?
in not
Please have. I'm reading.
My lord.
In not declaring the petitioner means you
Yes, my lord.
as selected tenderer or bid
Yes, ma'am.
in respect of the tender for transportation of a PM such and such, be they call letter dated such and such,
My lord.
be not quashed declaring the same as illegal and arbitrary.
My
That means
yes, ma'am. Intention is they have not declared me as the selected one. For that reason, that may be quashed. My prayer is yes.
is it?
Can it happen?
Is it? The prayer should have been couched in a very simple language. If I say from my lawyer's perspective, the first thing is the decision of this particular committee ought to have been quashed, right? For quashing and then setting aside. of
My
it.
lord, by that time they have not supplied the copy of
Please,
the sector.
then what for you have come?
My lord, because they have
And
not
what for?
in verbal they have stated that verbally they have stated that you are not selected. This person is selected.
Sir, where you have stated?
Yes, my lord, I have stated.
Where you have stated?
My
Now,
lord.
once they disclose this,
Yes.
will you not immediately ask?
I have immediately asked them by giving a representation supply me the copy.
Please, amendment of the prayer by virtue of a disclosure.
My lord, that is my fault.
Then
That is my fault. For that reason, first prayer is.
Now he's going by a strict rules of.
First prayer is there. Your lordship has ample power to declare me as a selected candidate. First prayer. Because
in an adversarial system of adjudication, the court has to decide on the basis of the readings which are made and the release claim. I know my powers of order 41 to 33 as an appellate court, but yet
well, I have stated in
Mr. Roth knows about it.
yes, ma'am.
I have that power of, rather we have a power as an appellate court, but
On page 8, your lordship, I have
but
stated.
this is the writ petition, not
Yes, fine.
I stand corrected.
Yes, fine.
Do something.
Amendment, I will go.
Whatever, do something.
But by that time, what will happen? He has already.
Please do something.
Well, I will amend it by tomorrow.
To that, I can't have anything to say.
First prayer is there. For that reason,
First the principal relief,
yes,
then the consequential relief. If you do not, the consequential relief, section 34 of the special relief act will come and catch you. Provides. That's the whole problem.
For that reason, in paragraph 8, I have elaborately, page 8, I have stated what happened.
Don't you know when you are meeting a civil lawyer? That's the problem. We are granting a leave.
Yes, ma'am.
The matter be listed on Monday. In the
Yes, ma'am.
meantime, the leave is granted to the petitioner to take up an application seeking amendment of a release claim with the instant what? Come on Monday.
Entry model is there.
Entry model is already there.
Yes, ma'am. There.
In Monday.
Item number 45.
Lordship, on the last revision, or 19/6/2025, state has sought for adjournment to file a counters if we have not had received the counter.
And if the state has filed the counter affidavit, filed, I am serving with copy to my land. Today we have filed it.
Where is that Murugan's case, Mr. Roth?
Yes,
Yes, Murugan's case. I have referred in many judgments.
And I'm giving a compilation of them. There are three judgments I have given. One is NG project, other is state of Jharkhand, and this one is. Para 26 is just flag for your lordship's convenience.
Yes.
Para 26 of this the Union of India judgment. If phrases are borrowed from Scots law, they would only mean that no party can be allowed to accept and reject the same thing, and thus one cannot blow it hot and cold. The principle behind the doctrine of election is inbuilt in the concept of a probate and reprobate. Once again, it is principle of equity coming under the contours of common law. Therefore, he who knows that he objects to an instrument, he will not get the benefit he wants. He cannot be allowed to do so while enjoying the fruits. One cannot take advantage of the one part while rejecting the rest. A person cannot be allowed to have the benefit of an instrument while questioning the share.
Correct. Yes, it's a Murugan's case based on this doctrine of election and the appropriate and reprobate at the same time.
Blowing hot and cold sermons.
Yes, yes.
The
copy has been served. What do you want? You want to file rejoinder?
Take some instruction, keep it next week.
Next week.
Right.
Is the matter?
Item 46.
Item 46 of the direction to be state. Affidavit, my God. Lordship, may kindly see order dated 13/5/2025. 13/5/2025. But they have received instruction that the case of the petitioner is that rehearse the provisions of the OPWD code, wherein wide publicity of the tender call notice should have been given. Ignoring the provisions, fellow, they went for a tender call notice. But they came up with the last occasion, they came up with the honorable court, and they submitted.
Have you filed your affidavit?
We need some time.
You say by tomorrow you will file. Here, you say that you have received the instruction. And you will file the affidavit by tomorrow, that is the 14th May.
Yes, but
Now we are in July.
it's like on Monday, the mistake.
If you do not, then they will proceed on that basis.
We will file on Monday.
No, what is this affidavit filed by not 53-4? What's that? It's called.
May I draw your lordship's attention to last order?
No, I was looking at the last order of 13th May and then asked you, paragraph 3.
This is relating to whether that tender call notice was sought to the contractors association or not. That is the crux of the matter.
Would you like to file affidavit or do not like to file?
We will file affidavit. Lordship, column this matter on Monday, by tomorrow.
Monday?
Paying for the OP number 6. My brother, will prove number 5.
Item 47.
Entry order to front of me. Separation of additional document. This is 13/5/2025 and additional affidavit. Just now I received the additional affidavit.
It is filed before.
Ignore it, madam. Would your lordship kindly see, this is a very unfortunate case. My mind is not shut for more than 4 months. And every day your lordships have heard a few cases where MDPA is charged if you are not binding and dispatching. Now kindly see minutes. It is an order passed after hearing counsels for both the parties. And the order was passed on 13th of May 2025. Would your lordships kindly permit me to read this order slowly? My lords, may see paragraph 2. My lord, this is Raman has a copy of the order. You. The essential grievance of the petitioners is against the demand raised by the opposite party number 2 by order dated 2nd of November 2022 as affirmed by the order dated 1st of May 2025 passed by the revision of them. Several grounds have been taken on the side of the petitioners and they merit deeper consideration. These are what? Summer vacation is fast approaching. It is difficult to take up the main matter to a hearing for positive time and also regards to the other pressing cases. So, Mr. So and so, there is both of us, appearing on behalf of the petitioners, ably assisted by so and so, submit that there is an imminent need for interim protection of their rights because denial of transit permits on the ground that the petitioners have allegedly in areas of huge sums of money is not legally or factually right. There is already interdiction towards the proceedings for recovery of so and so by virtue of interim order dated so and so. In respect of 4.35, there is a stay of recovery of the original proceedings that came to be decided against the petitioner in recent past. The appropriate procedure for recovery of dues, if any, provided under the legal framework, the denial of transit permit cannot be resorted as a legally recognized mode of recovery. If transit permits are not issued, that would virtually amount to closing industrial activities, and that in turn would not affect only the capital but the labor as well. Workmen need to be paid wages and the liabilities that are meant to be discharged. After all, the petitioner was not ordered from the scene, having established so and so. Lastly, the petitioners furnished the bank guarantee for the amount. This is what we suggested, what your lordship directed. Per contra, Mr. Pandal and his appearing for the state and its functionaries, government previously fails
for interim protection with the following contentions. Petitioners have huge areas and money, and therefore till payment of made clearing of the same, they are not entitled to grant the transit permit. Mode of recovery fits into the statutory protocol, therefore cannot be faltered. Lordship, I kindly see para 5. Having heard the counsel for the parties, therefore, my lords, this is an order passed after hearing both the sides. And having perused the petition papers, we are inclined to grant interim protection as under and or for the following reasons. So reasons are indicated. It hardly needs to be stated that running of industries of this kind is not a so and so. Huge capital and equally huge labor cooperate with each other. And that is how industry is established. And the productive activities are carried on. A workman cannot be sent home because of interdiction by industrial activity by virtue of denial of transit permits. They have to hold their body and soul together, and therefore the income has to be generated as necessary. Denial of transit permits would materially prejudice this. Any amount of work generated from the mining field will not only aid any money in its transportation, facilitate commerce takes place. It would need be stated that in so many words, apart from the incurred, what is incurred for labor force, there will be other liabilities. No purpose will be served by withholding transit permits. Now, this is important. True it is that the petitioners as of now are saddled with demand notices for huge sums of money, 11 crores per so and so. It is not disputed before us that coercive proceedings, but this is really important, for sum of rupees 11.77 crores are temporarily halted by an interim order of this court in a pending writ petition. However, that does not mean that petitioners can ignore the said disputed liability if they want to retrieve at our hands. There is force in the submission of learned AGA, Mr. Panda, that the liability of the petitioners who operate mining industry in question will progressively escalate as time runs. He also justified by telling us the affairs of state cannot be run by guarantee. The state needs hard funds and multiple activities involving interest and welfare. Prejudice should be caused if some fire media between two extremes is struck as a golden mean. Offer of bank guarantee could not do. Petitioners have to make payment in a reasonable sum, which is pending dispute. In our considered views, that reasonable sum would be rupees so and so plus 1/2. So let this 1/2, your lordship was already stated, notwithstanding that. Your lordship said that deposit 4.35 and for that 11.77, which there was a stay, you still pay half of it. Now, let us see the directions. The petitioner shall pay to the jurisdictional officer, opposite party, 4.35 crores plus 6 crores, that is half of that 11.77, within outer limit of 1 week. On the receipt of the above amount, the opposite party number 1 shall forthwith cause to be issued transit permits and such permits as are required for the transportation of minerals 1 from the field in question, subject to requisite compliance. This, the lordship said forthwith. The subject interim arrangement shall be without prejudice to the contention of the parties, and the petitioner shall not plead equity on the basis of this arrangement. They have filed a counter. In the counter, it is admitted that both the monies have been paid. Flag B. That is at flag B. B. I'm sorry, it's flag B. My lords have the counter. Flag D, internal page 10. Flag B. D for Delhi. Oh, Delhi. Grateful. Page 10, my lords, internal page 10. I'm grateful to my learned friend that in compliance with the aforesaid order dated so and so, petitioner has duly deposited the amount of 4.35 crores so that they acknowledge the compliance and the order of this. I'm grateful. So, your lordship said on the past 2 occasions when my learned friend was appearing, had asked them to take instructions as to why transit permits. But kindly see, Lord, if transit permits are granted to me, not only will I transport the mineral, they will also get royalty, taxes, so many things. But my predicament is mine is closed for 4 months. Your lordship knows there's an NDP arrangement, you have to do 80% of this, otherwise again penalty. So it will be jeopardy, double jeopardy for. No, let my learned friend implement your lordship's order. Me having done discharge my obligation. It is only fair and equitable that they do the same.
Since my last senior was facing, I didn't say anything. Actually, as a matter of fact, from the counter, I have seen the counter. This has been admitted in terms of the lordship's order. It has been complied with. This portion. What I intended to say from the beginning, my lord, an additional affidavit it has been filed, some documents of the month of July have been enclosed. This is an order passed in the month of May. That has been, a part of the order has been complied with regarding deposit. Subsequent documents are there, I couldn't take
These
any
documents
stress over
only
this.
show that I have
This is given
paid.
to me right now.
Now that you have filed in their counter and you have accepted it's paid.
The question is, if there was an interim order passed.
That has been complied.
Says that in the event if they default,
Yes,
despite an interdict having been passed by a court against a recovery of the.
Grateful.
This amount, then in that event, you cannot withhold.
Yes.
The transit permits.
yes, my lord.
If the transit permit is, I would say the sine qua non for the mining operations there, because without that, if
They cannot.
they extract the
Great.
mines, but if they cannot transport it, then what is the purpose
But-
for a use of mining activities?
I
So
think,
in that event, why even, how can you withhold it?
I think, my lord, by Monday.
Not, because you can't put at halt
I understand
the entire mining activities. You have received a substantial amount.
amount. Already.
Secondly, you are losing a recurring income.
Yes, great. Grateful. And this order was passed after hearing them. It's not an ex parte.
I don't dispute it.
Interim order.
I'm so sorry.
All, even
I'm
after
sorry.
without,
If my
Without
learned friend
any
says you will not pay
pleadings, that
Monday,
was
it's
done.
grateful.
I'm great.
that was done.
As a matter of fact, I have already written to them. I'm expecting it to
But
be
you
completed by
can't,
Monday.
this has some kind of an impact on the development and the growth. If the revenue is impeded, then how the development works.
Stable. Your lordship may call it on 22nd by 21st. And today is
We are on already a 17.
17th.
Come on, 21st.
You
have
have
been
to
here for such a long
meantime,
time.
they should give me
It's the
transit.
last time.
Yes, ma'am.
You have to convey, otherwise
Yes, ma'am.
we will say that you implement the interim order, otherwise.
Yes, ma'am.
Is you are representing another set?
No, we are together.
In the same boat.
What my learned friend says is if your lordship don't pass an order, they will not implement it.
No.
If two giants sail on the same boat, then boat will not know, the boat may not capsize because of the evidence.
Great. That is it.
I submitted that
Like
right
the
on
other
day.
writers.
No.
The humor.
There should be some kind
There
of.
should be some humor in court.
Some humor is required. Extent of space.
We are placing that you also pass some order that you better recover.
Yes, you just think.
My learned friend says that if your lordship make an observation, easier for us.
state. Is for a motion to take. You know,
I do.
I remember.
He gets, no? He's okay with
Can it be only 22nd first?
No. Tomorrow you have a good day. Working.
Working day or you are?
Even Saturdays are working in the government. Third Saturday. 2 days.
Yes.
Yes.
Item 48. grateful.
In this case, I want 2 ways to file counter. This came about before the vacation on page 6. The direction want to have a
Your
little.
first extension.
I have not.
This
This
2
is
weeks time. Extension.
Ma'am. Item 49.
Since the state has filed some of the counter, we need some time to file its reply.
How much?
3 weeks.
3 weeks time for reply. How much time they took for counter? Yes? 2 weeks.
Item 50.
I am appearing on behalf of respondent. Today I am filing the objection to the IA delay controversial petition. 376 days. Copy. Yes. Copy.